Good afternoon, everybody, and welcome to the Appellate Division First Department. We have about 7 hours of oral arguments scheduled based on your request. So since I don't think anybody wants to still be sitting here at 9 o'clock tonight, I would appreciate if you just ask for the time that you really need. Remember, we have had your briefs and your record, and we are familiar with the cases, and we just want you to hone in on the really important points and to answer the questions we may have. I'm going to call out the calendar. If both sides will stand up, you'll tell me how much time you request, and we'll let you know what we're able to give you today. Just remember when you're arguing that when the white light goes on, that means you have 2 more minutes. When the red light goes on, it means that you should finish up what you're saying since you're out of time. If we have additional questions, we will nonetheless ask it even if the light goes on. Okay, so the call of the calendar. The first case is People versus Hodson. Appellant?
Appellant 8 and 1, please.
I'm going to do 6 and 1 and 6. If you need something else, we'll let you go on. Thank you. Fisher versus City of New York. And respondent? We'll do 6 and 2 and 7. Thank you. C. Jorge versus Julieta C. is submitted. Ferrera versus EJ Electric. I'm going to do 5 and 2 and 5. Thank you. In re the Community Church of New York.
Appellate 15.
Statutory party and also the Attorney General, 5 minutes.
Church, 4 minutes, please.
Okay, I'm going to give you, sir, 5 minutes and 2 for rebuttal. And I'll give you, each of you, a respondent's 4. Thank you. People versus Mendoza. Okay, 5, 1, and 5. Thank you. Children's Magical Garden versus Maron.
Appellant's 5 and 2.
Okay, and respondent? Okay, 5, 2, and 5. Thank you. Knight versus Ammon.
Appellant requests 5 and 1, Your Honor.
Okay, respondent?
Respondent 5.
Okay, you got it. 5, 1, and 5. Zeitlin versus Cohan.
Appellate 10 and 2, Your Honor. Respondent 8, Your Honor.
Okay, I'll give you 6 and 2 and 7. If you don't finish, we'll figure out a way to deal with it. Don't worry. Have a seat. O'Shea versus Proceda Construction. Okay, and respondent? Okay.
5 2, Your Honor.
Now, you have a cross appeal? So 5 and 1, for 5 and 2, and 5 for respondent. Thank you all. People versus Bueno.
Good afternoon. Appellant requests 6 and 2.
I'll give you 5, 1, and 5. Thank you. Aaron Law versus New York City Police Department. Submitted. Mira versus Argus Media. And respondent? Okay, 5, 2, and 5. Thank you. 829 Greenwich Street versus Slauer.
Appellate requests 5 and 2, Your Honor.
Okay, respondent?
Respondent 5 minutes.
Okay, you got it. 5, 2, and 5. Broom Lender versus Empire Broom.
Appellate 6 and 2, please.
Okay, respondent?
Respondent 6 minutes.
Okay, 6, 2, and 6. People versus Jones is submitted. Cardenas versus State of New York is submitted. And 13 East 124th is submitted. first case to be argued is People versus Hodson. Okay, good afternoon. You may begin.
Good afternoon, Your Honors. Rachel Pecker of the Legal Aid Society on behalf of Appellant Mr. Hodson. I'm going to focus my argument on point 2 of my briefs today. Of course, I'm happy to answer any questions the court has. Your Honors, the trial court's decision to handcuff Mr. Hodson during the jury verdict and polling over the defense objection violated his constitutional rights. The court made 2 critical errors. First, the judge was under the fundamental misimpression that the verdict was not part of the guilt phase at trial and that the defendant could not, as a matter of law, be prejudiced by being shackled during it. The court said, if the jury found him guilty, it's not going to change if they see him handcuffed.
Counsel, you just said over the defendant's objection. Did the defendant object?
Yes, Your Honor. The legal advisor objected. It was nearly identical to the objection by defense counsel in People v. Sanders. Absolutely objected to. There
was a description by the prosecutor as to how, I'm not sure what the right word is, how it was not possible or that the jury would see the defendant's handcuffs. And I believe that the record was, there was nothing in the record indicating that defense counsel challenged that representation.
Correct, Your Honor. And it doesn't matter that we don't know whether the handcuffs were visible or not. In People v. Cruz, the court also could not determine, like this court cannot determine whether they were visible or not, but they were handcuffs, not shackles. And the Court of Appeals said the mere introduction of handcuffs into the trial automatically risks their discovery and shows prejudice, whether or not we know that they have been seen. And
That's not to say that a court could not, in an appropriate circumstance, use restraints.
Correct, Your Honor.
And isn't that what happened here? And here we have a defendant that is charged with an exceptionally violent act. We have a defendant that threatened his counsel to the extent that counsel asked to be relieved. And then we have a defendant that, while incarcerated in this matter, attacked a medic, knocking 5 teeth out of his mouth.
Correct, Your Honor. And the legal standard here, so first, the guilt phase of trial is part of the trial. Shackling can be prejudicial, and I believe it was prejudicial here. But second, going to Your Honor's point, the judge had to put adequate case-specific findings on the record specific to this defendant. And he could have done that, but he did not do that. And I'll go through why that is. So the prosecutor here made a written motion for restraints and then raised it 3 additional times. The first time, Judge Farbert knew about the Rikers incident and said, there is no record of this defendant acting up in court. I would be very reluctant to have him handcuffed in front of the jury because of the extreme prejudice. The second time was pre-trial, and Judge Mershon, again, considers the Rikers incident, and he says, there is extreme prejudice if the jury sees the shackles, and my shackling him is going to have a hard time standing up on appeal, so I'm not going to handcuff him. The third time,
Wait, counsel,
Sure.
I thought that Judge Farber did order him to be placed in leg shackles due to his strong record of unprovoked attacks.
He
did.
Judge Ferber put him in leg shackles and
Right.
said for trial it would be a different determination that will have to be reached.
I thought you said he didn't.
Sorry, he said I would be very reluctant to
But he did. He
put
did
him in
it,
leg shackles.
right?
Yes, and Judge Mershon put him in handcuffs outside the presence of the jury.
Right,
But this
okay.
was about the prejudice if the jury were to see him. And so when it comes to the third time, Your Honor, that the judge now changes his mind, each time except the last, the court concluded it would be too prejudicial for the jury to see, and nothing had changed except at the last determination, the judge now thought that there could not be prejudice, which was wrong as a matter of law. And I'll go to your point.
Wait. In between the second and the third time, didn't the counsels ask to be relieved because the defendant threatened him?
But the Judge Mershon did not put that on your record, Your Honor. Yes, you're correct. Judge Mershon said, for all the reasons already set forth on the record, I am going to handcuff him.
But that's part of the record, isn't it?
Right.
Part of the record. He made a motion to be relieved that was granted, and then at some point the judge asked him to rejoin, and he did.
I think that general statement and the one that followed that Judge Mershon gave, which was, I'm also shackling him because of concerns by my court personnel. If you look at what the judge put on the record in People v. Cruz, and I would encourage you to do so, I think you'll find it's very similar. In People v. Cruz, the judge listed what looked like was individual factors, and the judge said, this defendant is no stranger to the criminal justice system. He's been a threat to society. There's potential for disruption in this case, and he's looking at a long prison sentence when the court comes in. And then the judge said, and my security personnel is worried about him being shackled. And the Court of Appeals said that was not enough. Assault 1, Assault 2 charges, that is inadequate justification.
But here we have more than that, right? Here, in terms of what happened with the defense attorney was delivering bad news to him with regards to the DNA expert. The defendant did not accept that bad news kindly and threatened the defense counsel to the point the defense counsel saw it fit to ask to be relieved. Now we're at a junction where he went the whole trial without any restraints.
Correct.
Right? Despite the court knowing all this, went the whole trial without any restraints. And it was at the point in time where he, again, the possibility of bad news was going to be delivered to him in terms of a verdict. That's when the court exercises discretion and puts handcuffs on him.
And Judge Mershon also noted that the court personnel had asked him to restrain the defendant during the reading of the verdict, and that their safety and well-being was also very much a factor. So he referred to things that had been put on the record throughout the trial, and he made some additional findings. If you just want to respond, and then I'll hear from the others.
Sure, Your Honor. I think we still have a major legal error that he did not understand that this was part of the trial, and that affected his calculus. He says there's no prejudice if an individual is handcuffed when during the guilt jury polling and the verdict phase. And so we have that legal error. And then responding to you, Your Honor, I still think the general statement for all the reasons set forth already, when he did not make individual findings on the record, the only thing that had changed was his understanding of prejudice. I don't think that is an adequate justification particular to this defendant on trial.
Okay.
Thank you, Your Honor.
Good afternoon, Your Honors, and may it please the court. Samuel Goldfein on behalf of the people. First, with respect to the handcuffing, as Your Honors pointed out, the handcuffs were not visible to the jury. The prosecutor made that.
How do we know that?
We know that for two reasons, Your Honor. The prosecutor represented to the courtroom that given to the court that given the layout of the courtroom.
It's a standard layout.
Absolutely, Your Honor. But he then asked the judge to take judicial notice of the fact that the layout would prevent the jury from seeing the handcuffs. Now, the judge didn't respond directly, but the next words out of his mouth are, I also note. And that's when he went on to point out that the security had requested specifically that this defendant be restrained. But I think that given the judge is accepting the prosecutor's representation that the layout of the courtroom will prevent the jury from seeing the handcuffs, certainly neither defense counsel or defendant objects or makes any sort of objects to the prosecutor's representation that the layout will prevent the jury from seeing the handcuffs. But here, even if the jury did see the handcuffs, there are a number of very case-specific factors of this defendant's sudden outbursts of violence that justified handcuffing him. In Cruz, it was really about, and in Sanders, it was just the criminal history. There was no other finding. But here we have the violence in this case, the attack on the healthcare worker at Rikers Island.
Counsel, what do you say about your adversary's argument that Judge Mershon misunderstood the law about shackling and citing that statement where he said, well, there's not going to be any prejudice at this point?
I believe Justice Mershon was unsure about the amount of prejudice, and in that moment, the defendant's legal advisor did what he's supposed to do. He objected and he explained the law, which is that there was a potential for prejudice during the rendition of the verdict and the polling of the jury. Nobody disagreed with that statement. The prosecutor goes on to point out that the handcuffs wouldn't be visible, and the judge ultimately rules, I quote, that the risks outweigh any possible prejudice, a ruling that inherently recognizes that there is possible prejudice during the rendition of the verdict.
So do you think that that was a misstatement of the law?
His initial statement, perhaps was not fully a full, accurate articulation of the law, but his ultimate ruling is spot on what the law requires.
A balancing of the prejudice.
Of the prejudice versus the risk. And here, Your Honor, I mean, there's extreme risk. The prejudice is minimal. Again, this is not that there's no prejudice, but they've already reached a verdict. They've already evaluated the evidence. There's certainly a lesser standard of prejudice. And the risk is extreme. He's about to face potential significant sentence.
Counsel, what changed here in terms of he went the whole trial without any restraints, and then now we need the restraints for the verdict. But the information, the basis for that would justify putting the restraints on for verdict existed throughout.
Well, there's a couple change in circumstances, being that he's facing now very significant jail time. I mean, the verdict announcement is going to be a big moment in the trial. His reason for not for behaving himself previously was that he wanted to be able to continue to represent himself. That was no longer going to be a factor in the analysis. And I think given the risk factors, I mean, beforehand, I think it would have been okay to justify. It would have been justified to restrain him throughout portions of the trial, given his violent history and his violent acts in this case and while incarcerated pending trial. But
do you agree with the general proposition that handcuffing a criminal defendant during the trial is something that should not happen?
I would agree with the general proposition, absolutely, Your Honor. I think this case presented very specific, very egregious, and extreme factors that warranted restraining this particular defendant. But I would agree absolutely that as a general rule, it shouldn't be condoned. If there are no further questions about that point, any of the other points, I'm happy to answer. Thank you very much. I rest on my brief and ask that you affirm.
Thank you, counsel.
Responding just quickly to your question from my adversary, I think we're now opining what Judge Mershon might have considered in his calculus, and the point is that it was not adequately placed on the record, which People v. Cruz and People v. Sanders and all of these cases said he had to do.
But what do we make of the fact that defense counsel didn't say anything when the people said that the shackles would not be visible? Can't we draw an inference from that, that defendant's counsel didn't dispute that?
I don't think so, Your Honor, because they were saying this is what's going to happen. The attorney himself said, I think there'll be prejudice if he's shackled at this point. And the prosecutor asked the judge to take judicial notice, and the judge didn't respond to that. And this issue was never raised again. And so we don't know. And in Cruz, they didn't know either, and they found that the introduction was prejudicial. It also happened, I'll just add, against the backdrop of him being clothed in tan and brown prison clothing, which should never have been allowed to happen in this case.
That's something that defense counsel and the defendant specifically agreed to.
No, Your Honor. Mr. Hodson said to the court, Your Honor, I'm wearing my jail uniform and I don't have anything else to wear. And the court said to him, it's fine. That was found, a similar objection was considered preserved in People v. Clyde, albeit in the restraint context. In People v. Clyde, a pro se defendant, Mr. Clyde, had a conversation with the prosecutor and the court regarding restraints. And there the court decided to restrain him in part. And the Court of Appeals said that the defendant, pro se defendant, having raised it, it was preserved. They did not find it unpreserved, and they reversed. And I think that's the same here. He said, I'm wearing my jail uniform. I don't have anything else to wear. And that never should have happened. It was a communication to the jury all throughout trial that he was guilty. And so given the legal error here and given the inadequate justification, given the prejudice.
And this is subject to harmless error, right?
It is, Your Honor.
And how was and are you saying that there wasn't overwhelming evidence of his guilt?
Correct, that is what I'm saying, Your Honor.
Okay.
I do not think there is, for the reasons set forth in point 1 of my brief, and I'm happy to address if you have questions about that. I don't think there was, yes.
Okay, thank you. Thank you
Thank you.
both. The next case for argument is Fisher versus City of New York. Good afternoon.
Good afternoon, and may it please the court. Chloe Moon on behalf of the appellant. Supreme Court wrongly granted the disclosure of highly detailed personal questionnaires filled out by judicial candidates, not nominees, many of whom remain private citizens and who were assured confidentiality. The court erred in
Isn't there
failing.
a strong public interest in the public knowing as much information as possible on judicial candidates?
Yes, we recognize there's an interest in transparency, but there's also an interest here where confidentiality has been assured. And I point the court to Harbatkin, the 2012 Court of Appeals case, which says even a small risk of harm or embarrassment where assurances of confidentiality have been given allow for the privacy exemption to be invoked.
And that assurance came in the, I'm sorry.
Go ahead.
That assurance came in the form of confidential right on top of the questionnaire, correct?
Exactly, Your Honor, in big, bold letters at the top. And this has been a decades-long practice. And really, ultimately, we think that the confidentiality here is a through line of the case. Not only in Snyder, the third department case, was it recognized that confidentiality is a necessity in the process, but also in Harbotkin and these other cases where it's clear that confidentiality serves a critical role in garnering highly qualified candidates. Some of the most private information.
Couldn't the confidentiality concerns have been addressed by a system of redacting?
We don't think so, Your Honor, because even releasing the names alone pose privacy concerns. So the prestigious positions that many people who are judicial candidates are in have clients and partners and colleagues for whom even releasing the name would pose privacy concerns for them. 1 foot out the door, or perhaps damaging reputational harms from the fact that they maybe were unsuccessful as candidates or they are looking to leave their current positions. But we also think that redactions, the kind of redactions that would be required here would be so thorough that would actually lose some of the public interest in the questionnaires. And then finally, even if redacted, even if heavily redacted, disclosure would still chill the number of applicants that you would get because you have this highly personal, highly private information coming out in these questionnaires. So think about bankruptcy, past drug and alcohol use, second homes, discipline, even when not proven, and essay questions that are in narrative form that could talk about childhood trauma or family history with the criminal justice system, things that are only being
And then we have
discussed.
that last question, the open-ended question, right? About tell us anything else that could impact.
Anything else, even anything that's potentially unfavorable. These kind of open-ended essay questions have so much privacy entailed in them. And we really think that that information is necessary for an advisory body to be looking at to make sure it knows everything. But we think it's so private that we think the privacy exemption applies.
What effect, if any, does the letter from the Committee on Open Government that was sent to the petitioner, I guess, in between when his request was denied and when he came for his appeal, where they came out a little bit differently? What weight, if anything, are we giving to that?
Yes, we think the COG opinion is only relevant to the extent that it's persuasive, and it's not persuasive here. The COG opinion misses some clear exemptions that are in the FOIL law, so we just don't think it's really reliable here or persuasive here. And ultimately, we think that this court should not take and does not need to take that into consideration here.
Any more questions?
The court has no further questions. We ask this court to reverse. Thank you so much.
Okay, thank you. You'll have a minute or two on rebuttal in any event. Thank you. Good afternoon.
Good afternoon. May it please the court, Connor Flannery. I'm a certified law intern with the Cornell First Amendment Clinic. My supervising attorneys, Heather Murray and Christina Nyetse, are present. Appellant argues that every portion of the questionnaire should be withheld because of privacy and safety concerns, but appellants cannot satisfy their burden of proof.
But how do you deal with the fact that an applicant for a judgeship might be working for a law firm where the applicant has not disclosed to his or her law firm that they're applying for a judgeship, and the mere fact of that being disclosed might have an impact on the person's current employment? So no matter what redactions there are, why wouldn't the mere disclosure be sufficient to significantly harm an applicant who has an ongoing job which might be jeopardized by the disclosure that he or she has applied for a judgeship?
Well, Your Honor, when applying for positions of public office, there's some privacy interest is diminished. And whatever is left of that privacy interest, the public interest in having a transparent process and being able to assess the qualifications of who ultimately will sit on New York City's criminal, civil, and family courts outweighs that diminished privacy interest.
So, question 3, date, place of birth, and country of citizenship. That's required. So now that would be public for everyone, including people who are scraping information to steal your credit cards. Now that's all public because you've gotten it. If you're a naturalized citizen, a clear copy of your citizen certificate of naturalization also now open to anyone in the world looking at and being able to use in nefarious ways. Here's another one. If you've ever been subpoenaed in a litigation, maybe I'm a witness or a victim of a sexual assault, and I've been subpoenaed to appear before a grand jury, and I have to answer that question in this questionnaire. Now that's open for the entire world to know. Here's another one. Have you ever had a complaint filed against you, regardless of, as an attorney, regardless of whether or not the disciplinary body found no merit to the complaint? It was by someone who had a personal grudge or something else. Again, all of that has to be disclosed. Are you a litigant in a litigation? Maybe I'm suing my ex, or maybe I'm in the midst of a sexual assault suit. All of that now, all of it open to public view. And you're saying that the public's right to know about judicial candidates outweighs all of those privacy concerns?
Well, not all of it entirely, Your Honor. Again, we've consistently agreed to redact some of the
Well,
sensitive.
who's going to redact it? You didn't offer to, the court didn't say, let me, and so you're asking some judge to spend hours and hours and hours going through 50, 60, 100, 200 pieces of information and deciding what to redact and what not to redact each time you make a FOIL request?
Your Honor, below the Supreme Court began to start recommending redactions, but then gave the city the burden of picking which redactions they would choose, and then we would go from there. And in the process of that, Supreme Court stopped himself, Justice Hagler stopped himself and said, well, I will assume the positive here and assume that they won't over-redact.
So in the state of California, for example, you would not have to give your name and address to anyone. It's your private, personal information that is yours to hold and keep, and if someone wants it, they have to buy it from you. And now here you are giving that information to the entire world for free, right? And how does it impact with all our data privacy laws in New York?
Well, Your Honor, I can't speak to the data privacy laws specifically, but I think our position is that this information is stuff that if it were any other judicial bench, whether election for the state, or this information is public, and that's part of the nature of public office.
I don't think that's right. I can tell you honestly, as an elected judge in New York, most of this information about if I had answered this questionnaire is not public.
I mean, they all say confidential, and that's what's promised when we all fill out these applications, which we've all filled out.
Right, but confidential isn't a FOIL exemption, Your Honor. And there's case law from this court that has said that you can't contract around a FOIL exemption just by labeling confidentiality on the questionnaire.
What effect does that have on the expectations of the people who apply for judgeships and expect that the information on the questionnaire will be confidential? Isn't there some public interest in honoring the representation that this information will be confidential, and couldn't it have a severe chilling effect on the applications of potential judicial candidates if that was not the case?
Well, Your Honor, we've seen in other states specifically that when the process is open and more transparent, that it actually improves the diversity and the quality of candidates that are applying.
And does that apply to this kind of information sought in this questionnaire, which, as Justice Scarpula just set out, is so extensive and so potentially invasive?
Again, Your Honor, the sensitive and invasive aspects of the questionnaire we have consistently agreed can and should be redacted.
Where do you say that in your papers? And where is it set out what should be redacted?
Believe residential addresses, social security numbers. On some level, it's going to be a case-to-case basis, but at the core, we're looking for the information. May I finish? At the core, we're looking for information that is a resume. We're looking for education, bar admission, licensure, all that stuff that the public has a right to know for the people who are representing them among New York City's courts.
Okay. Thank you very much.
Just a few quick things, Your Honor. Honors.
Can I just ask you quickly, how do you respond to the argument, well, we can just redact?
Yeah, so we think that redaction is not sufficient here. as I was saying earlier, the names alone pose privacy concerns. Also, the redaction would just be so heavy here because of how intrusive these questionnaires are, that it would deprive the questionnaires of any public interest, really. And we also don't have any indication from our adversary that such extensive redactions, they would actually be interested in these questionnaires anymore if that were true. The Supreme Court below found that there were only limited redactions and didn't specify which they were, and even within the oral argument transcript, it was contradictory what specific limited redactions, and we just don't think redactions here are enough to protect where there have been those assurances of confidentiality. Those assurances of confidentiality, we think, really protect the government functioning here, the chilling effect that we've mentioned in our brief and has been made clear here today, but also it reflects the privacy interest in those documents.
Isn't there a chance for public comment after the candidates have been selected at a time when the public can then comment on their fitness to serve?
Yes, Your Honor, exactly. The specific nominees and the candidates appointed have hearings, public hearings, so that the public can contribute, and they also have summaries similar to resumes, quite literally what they've done in the past, shared publicly. And finally, just one point I'd like to make clear that my adversary, again today, said that this is about who will ultimately be sitting. That's not true. His request is for all candidates, many of whom remain private citizens. So I just wanted to emphasize that. And truly, we ask this court to reverse. Thank you so much.
Thanks.
Thank you. And we understand you are a law intern. Is that what you are?
Yes, I graduated in
Okay, well, thank you very much. You did a great job. You both did a great job. We always am happy to see new young lawyers coming and argue before us, and we wish you the best of luck. Thank you both. The next case for argument is Ferrera versus EJ Electric.
Good afternoon, Your Honors. Kevin Pollack from Fabiani, Cohan, and Hall on behalf of the defendants' appellants. The lower court incorrectly granted liability in favor of the plaintiff, and additionally, on top of that, to add insult to injury, the judge struck the defendants' affirmative defenses of culpable conduct. The judge was wrong on both counts. What makes this case different than the typical rear-end collision case are the facts. This is not a case where the plaintiff was stopped at a red light or a stop sign and was rear-ended. It's not a case where there was stop-and-go traffic and the plaintiff was struck from behind. What this case involves a situation where both the plaintiff and defendant were traveling in a steady flow of traffic with the defendant 1 to 2 car lengths behind. The defendant decided to change lanes to avoid an on-ramp to the Bronx River Parkway. He waited until there was an opening in the left lane. He put his directional on, left directional, turned his wheel to the left, started to move into the left lane, and then what makes this case different is that the plaintiff suddenly and for no reason stopped. That evidence, that testimony is unrefuted, unrebutted in this case. In response to the defendant's affidavit testimony in opposition to the plaintiff's motion that that is in fact what she did, the plaintiff did not come back with any affidavit from the plaintiff refuting that or disputing that. So in the record, once again, it is undisputed that while traveling in a steady flow of traffic, the plaintiff for no reason stopped her vehicle. And the fact that there was contact was a result of the fact that she stopped for no reason. And that is what provides the defendant with a non-negligent explanation for the contact between the two vehicles.
Doesn't that also indicate that he failed to maintain a safe distance?
I'm sorry?
Doesn't that also indicate that he failed to maintain a safe distance?
I don't think so. I mean, if you take that position, then every car accident is the defendant's fault or the rear driver's fault.
The ones from the back are.
No, because he was switching lanes. He wasn't continuing to go straight. He already started his turn. He, in fact, was almost completely in the left lane when she stopped. So I don't see how that's a failure to maintain a safe
But there's
distance.
no less an obligation to maintain a safe distance when you're changing lanes.
And he did, and had the plaintiff not suddenly, and for no reason whatsoever, stopped her vehicle, slammed on her brakes, there would have been no accident. The defendant would have completed his lane change, and the accident would not have happened. And this court has said, in cases, in Berger, in Baez-Pena, that the lead vehicle, for no reason, stopping is a non-negligent explanation for a rear-end hit. Again, it's not a case where...
Aren't those on highways? Aren't those cases, that exception for highway cases? Accidents happen on highways?
I think it's a motor vehicle exception. I mean, in this case, they were on East 177th Street, which was essentially the on-ramp for two highways, so I'm not sure that makes a difference in terms of the application of this court's acceptance of a sudden stop as being a non-negligent explanation for a hit.
How do you distinguish our decision in Agramonte versus City of New York from 2001, addressing the very question of when a front vehicle stops suddenly in slow-moving traffic, that's not sufficient?
Because here, again, in later cases, in Baez, Berger, which were subsequent to that case, and in Newell, which is in 2020, again, there was in this case, there was no explanation for the stop. There was no reason for the stop. It was arbitrarily a stop by the plaintiff, and that's what makes the difference. Again, it's not where it's stop-and-go traffic. You should expect someone to stop. The traffic was moving, and there was absolutely nothing, no condition, according to the defendant, and it's unrefuted. The plaintiff has not come back with an affidavit refuting this, that there was no traffic condition in front of her, no roadway condition in front of her that would have caused her to stop in the middle of the road. And again, that, at the very least, that unrefuted evidence creates an issue of fact as to her comparative fault, which at the very least should result in the reinstatement of the defendant's comparative fault, affirmative defenses. They're separate issues. Even if you find that the defendant was negligent, which we submit he wasn't, the separate issue is whether or not her stopping for no reason raises an issue of fact as to her negligence. And anybody stopping for no reason, it's plainly obvious that's negligent. And for that reason, our affirmative defenses should be reinstated at the very least. Thank you.
Okay, thank you, counsel. You'll have 2 minutes on rebuttal.
Good afternoon. May it please the court, Kelly Breslauer for the plaintiff respondent.
So how do you respond to the cases that Mr. Pollack raised about that would go cut against the judge's decision in this case?
Sure. So with respect to Berger, that involved a 5-car collision, and the issue was whether it was who stopped first. So that's why the court held there was an issue of fact, and I don't know if they reversed or denied summary judgment, but and then with Baez-Perez, this was the Major Deegan. Vehicles were traveling at 35 miles per hour. There were normal conditions, and suddenly the defendant's box truck suddenly struck the overpass. And so it's our position that those cases are distinguishable from here because you have cars which defendant in his affidavit states that yes, traffic was moving steadily, but he also says slowly. And so
weren't they approaching the entrance ramp to the northbound Bronx River Parkway at the time that this accident happened?
Yeah, so it was approximately 9 o'clock in the morning, and they were approaching, it's a 2-lane road, so the left lane is to the Cross Bronx, the right lane is to the North Bronx Parkway, the northbound side, the Bronx River Parkway, rather. And here, defendant testified in his affidavit, he says, I needed to get into the left lane because I wanted to stay and eventually get on the Cross Bronx. He didn't want to get on the northbound Bronx River Parkway exit. And so he says that, he essentially, while looking straight ahead and to the left through his side view mirror, he believes that he had enough time to change lanes. And so that's why he started to change lanes. And so essentially, it's our position too that, in opposition, he doesn't raise an issue of fact because he states, I thought I had enough time and I didn't. And with respect to my adversary's argument pertaining to plaintiff. Plaintiff never addressed the traffic conditions. I'm not aware of a case that says plaintiff's affidavit has to state the speed she was going, the distance. I mean, the point of those requirements is for a defendant because he's in the rear. And again, 1129A requires you maintain a safe distance. And it's also our position that hitting in the rear is evidence of negligence when, too, you have traffic that's moving slowly, and it's reasonably expected that someone might stop. And here, while, again, I have to concede that plaintiff doesn't in her affidavit say, I was stopping, ultimately, it's clear that traffic was moving slowly and steadily. They were getting onto an on-ramp, and defendant admits seeing the brakes. And so it's our position that the trial court got this right, and we would ask that this court affirms. Any questions?
Okay.
Thank you.
Thank you. Mr. Pollack?
I think I'm good. Thank you very much.
Okay, well, thank you very much, too, and have a very nice afternoon, both of you. The next case for argument is in Re Community Church of New York. You may begin. Good afternoon.
Good afternoon, Your Honors. I'm George Duckett, the appellant pro se. I'd like to update my bio by saying that I was indefinitely suspended from the community church for submitting an affidavit, the affidavit opposing the sale, and also for initiating this appeal. My stand is that the action, the sale, should be reversed because of erroneous actions by the court, the petitioner, and the OAG. The court disregarded, starting with the court disregarded the appellate's affidavit opposing the sale. The details of the appellant's allegations are in the brief, and I needn't go with that here. But I would like to mention that Mr. Duazzo's, that's the OAO respondent, erroneously characterized my comments at the hearing by saying that I reiterated all of my arguments and added something new. That's not true. What I did during the trial was to refute some questions that were on the table, and so nothing was added new. At the end of the argument, there were clearly open issues, and nothing was done about that. Okay.
Mr. Duckett?
Yes.
Did you speak to the Attorney General's office prior to the approval?
Yes.
Okay, so you were able to convey your concerns to the Attorney General, correct?
Yes.
And how about the court? Were you able to speak in court about your concerns with the sale?
You mean during the?
During the hearing, were you able to speak?
Yes.
Did you speak and state your concerns?
Yes.
So you were given opportunity there too. I just want to make sure you're not saying, I didn't have an opportunity. You had an opportunity and you did speak to the AG, and you had an opportunity and you did speak to the court. Okay.
Okay, but clearly, the affidavit was not included in the items that the court said they used to make the decision. And neither was any comment on the open issues. So that, I think, was an abuse of the court's discretionary power. As far as the action of the petitioner goes, the petitioner is ignoring the present worth when considering the sale of the church's assets was a source of misinformation during the contract negotiations and continues today. Mr. Shenfield uses more than 70 million in his brief response. He also uses 70,972,950, both describing the sale. These are not present worth values. They are future worth. He also does mention the present worth, which is 65 million. But again, it's misleading to talk about future worth when the present worth is the item that matters.
Okay, let's hear from your adversaries, and you'll have a few minutes to respond to their comments, okay? Thank you very much. Good afternoon.
Good afternoon. May it please the court, Seth Schinfeld from Kramer Levin for the Community Church of New York. No one is here today to question Mr. Duckett's passion or to convince him to support the ground lease and sale transaction that the Supreme Court approved last year. He may never support it, and that is his prerogative. However, he should not be allowed to unilaterally reverse and prevent it from going forward either. The petition that the church submitted to the Supreme Court last year included all of the information that is statutorily required for a not-for-profit religious corporation to seek and obtain approval to sell real estate assets under New York law.
Was there a vote of the members of the congregation? The
Yes, on
community
multiple
church?
occasions.
And how did those votes go? Were they all in favor of the sale?
Yes, the clear majority of the congregation voted in favor of the sale, the two most important occasions being October of 2021, when the initial closing agreement was presented to the congregation, and then again in May 2022, when the as amended closing agreement was presented. And
you were able, I mean, they were able to get a larger price by the time they closed than originally had been negotiated. Is that true?
That is correct, Your Honor. And to Mr. Duckett's point, there was an appraisal done in 2021. The appraisal price was around $63 million. The initial closing price, when net present valued, was below that number. After the Attorney General's office pointed that out to the church, they renegotiated the agreement to increase the price as well as shorten the closing time, the number of years. And in so doing, the total amount was $70 million, but the net present value was $65, which is higher than, again, the appraisal amount. So therefore, the purchase price does now exceed the market value of the property. Also, just to point out, as stated already, Mr. Duckett was given the opportunity to be heard by the court, and at the outset of the hearing in July of 2022, Justice Love stated that he had received and reviewed Mr. Duckett's papers. The reason that the decision and order does not reference an e-file number associated with Mr. Duckett's...
Because it wasn't e-filed.
Correct, Your Honor. Unless Your Honors have any further questions, I'll yield the rest of my time. Thank you.
Okay, thank you, counsel.
Good afternoon, and may it please this court, Anthony Radawazzo on behalf of the statutory party, the Office of the Attorney General. This court should affirm Supreme Court's decision to the extent Mr. Duckett challenges the Attorney General's review process, which he previously described as, quote, extremely beneficial, and which, by his own account, resulted in a $6 million increase in the sale of the church. Mr. Duckett's arguments are all legally irrelevant and unpreserved and should be rejected. First, Mr. Duckett has no basis for his claim that the Attorney General should have published a report along with the no objection determination. There's nothing in the not-for-profit corporation law or the religious corporation law that requires such a report, and our office is unaware of any other precedent, either in guidance or in case law from this court, that would require one here. I'll just note too, as a matter of practice, we review hundreds of transactions just like this every single year. We do, on time to time, submit an affirmation in Supreme Court when we have objections to a transaction or where there are points in the record that we want to clarify for the court. But as a matter of course, we do not produce a public report. I'll also
What's the mechanism by which the Attorney General's participation led to a higher price?
Yes, Your Honor. So here, as part of our guidance, we require that payments that are over a course of years be expressed in net present value terms. So when petitioners submitted their draft petition to us in late 2021, we reviewed it. We saw that there was such a payment of over a course of terms, and we realized that it was not expressed in net present value terms. We then went back to the church, told them of this oversight, and they then went and corrected this. The parties themselves realized, presumably at that point, that the sale price was below the appraisal value. As we explained at the July 2022 hearing, that's not necessarily a problem. They have to have a reason for that, and they have to explain that. But the parties themselves renegotiated the sale price. We were not part of that transaction in any way. I will also note that our reasons here, to the extent Mr. Duckett is concerned about information, our reasons for the no objection determination were clearly stated at the July 2022 hearing. We explained that we closely reviewed the communications given to church members to make sure that they were fully informed both of the October 2021 vote and the May 2022 vote here. We concluded that they were fully informed. I'll also note there's no merit to Mr. Duckett's argument that we failed to take into account his opposition. We spoke to Mr. Duckett along with several other congregants before we issued our no objection determination. After we received the petition, we always welcome comments from congregants like this. We took into consideration his comments and before reaching a no objection determination. We also listened to his comments at the July 2022 hearing before reaffirming that no objection determination. I think we addressed the conflict of interest point. We were not involved in the renegotiation of the sale price at all, but if there are any further questions, I welcome them. Otherwise, I ask that this court affirm.
Okay, thank you. Okay, Mr. Duckett, you have a couple minutes to respond or add anything you would like.
Okay, for one thing, the affidavit that I submitted was not filed.
Was not e-filed?
Was not filed in any way.
Oh.
It was said it was filed, but it was.
It was mailed to the court. How did the court get the affidavit?
It was mailed, and they acknowledged it.
Okay.
But there's no way of getting at it if it's not listed somewhere and printed somewhere. It was just.
Well, if the judge acknowledged he received it, then he received it and considered it.
How can you talk about it if you don't have a copy of it?
Well, who said he didn't have a copy of it? If you said you mailed it to him, he said he received it, so he had a copy of it.
Yeah, but it was never filed in such a way that it could be recalled and looked at. If I wasn't here today, it would not be anywhere in the record. The document itself, only references to it by the attorneys, but the document itself.
But you had an opportunity to speak at the hearings and before the judge, correct, and express your concerns.
Yes. Now, the other thing is, the way the law is written, the Attorney General's office has to be notified if the court is going to approve the sale. It doesn't describe, the law doesn't describe exactly what the Attorney General has to do. That is clarified in the guidelines. And in this particular case, the Attorney General, and the guidelines not only specifies that the Attorney General gets a chance to talk about the case, that is, rate the case. She also gets a chance to do back and forth and determine the terms of the contract. That's and then after she does that, she gets a chance to say, yes, this contract is fine.
Okay, well, I think we have your position, and we will certainly look at the papers some more. And we thank you all for coming in this afternoon.
Thank you.
Have a good day. The next case for argument is People versus Mendoza. Good afternoon.
Good afternoon, Your Honors. May it please the Court, Legal Aid Society by Robert Hopkins for Jose Gamera Mendoza. Your Honors, a downward departure should have been granted here by the lower court, mainly for two reasons. The first is that defense counsel had submitted mitigating evidence that showed Mr. Gamera had a reduced risk of recidivism. Mostly that evidence involved the fact that the relationship between Mr. Gamera Mendoza and the complainant was that of an intrafamilial type. The second reason is because, in totality, Mr. Gamera had a stable and productive lifestyle at the time of the offense.
But the fact that he had a stable, what you refer to as a stable lifestyle at the time of the offense, didn't prevent him from offending, right?
No, Judge, it didn't. And we're not certainly saying here that,
So why would that be a factor in favor of reducing the level if that stable lifestyle didn't prevent him from offending in a fairly heinous crime at the time?
Well, the question here, Your Honor, is whether it can be used as a factor to determine whether he can reoffend, not whether the conduct that he...
But when you say his stable lifestyle would make it unlikely that he'd reoffend, given that he had that stable lifestyle at the time of the 7 years of the 6 or 7 years of the offense, that didn't prevent him from offending. Why would we assume it would keep him from recidivating?
Well, going to my second point, Your Honor, which is about the productive lifestyle, defense counsel did submit evidence showing that one of the biggest indicators of recidivism is antisocial behavior, which Mr. Gamera does not engage in. He's very social. As you can see that, first of all, he's 38 years old when he took this plea. And he pled guilty for conduct that he committed when he was in his 24 years old. He's a substantially different person now than he is then. And this is his first contact with the criminal justice system.
Also, the mitigation that you speak about now, isn't that considered by Factor 15, which is an offender is assessed 10 points in this category if either his work or a living environment is inappropriate? He was assessed 0 points.
Well, yes, that is encapsulated in that category, yes, Your Honor. But there are other factors here that are not reflected in the REI. The first is the intrafamilial relationship.
Well, that one I think it is factored. It's factored on 7, right?
That's what respondent argues, yes. But however, our position is that it's not adequate, which is a standard under Gelati. First of all, Factor 7 only breaks up the relationship between strangers and non-strangers. It doesn't take into account that non-strangers may recede at different types of rates. So when you have the intrafamilial component, which defense counsel had argued below, it is a very, very low recidivism rate. The study that was introduced by defense counsel at the SORA hearing was out of 1,100 offenders. They had followed them for a period of 17 years, and during that 17-year period, 90% of them did not reoffend. So that was the...
Overall here, he gets a sentence of 3.5 years, and the allegation is that he molested this child for 6. Isn't that egregious?
The conduct is egregious, yes, Your Honor. We're not arguing that it's not.
Doesn't that outweigh any mitigation that he could possibly put forward?
No, Your Honor. The standard is made under Gelati. The question before this court, we're not here to argue that, trying to overturn a conviction. We're not hiding from the conduct. The question is whether this is likely to happen again. And based on the evidence that was submitted at the hearing, which defense counsel put forward, such that he has a stable lifestyle, he's been in the country for 11 years, maintained the same job, the same residence for that entire span of time. Even while he was incarcerated,
Wasn't he released to the custody of immigration, so he's not a citizen?
He's not in the country anymore, Your Honor, but he was released to immigration customs. And he did serve, he is from Mexico, he served in the Mexican army for about 3.5 years. But if you also look, Your Honors, if you want determine the type of person he is today, if you look at his jail record while he was incarcerated, he has no Tier 2 or Tier 3 disciplinary
How
sanction.
long was he incarcerated? It seems to me it was only a few months.
Upstate, yes, correct. But he was in custody for about 3.5 years. So during that time, he had no issues. Nothing part of this record shows that he had any issues while he was incarcerated. So based on all that, Your Honors, and based on the intrafamilial component, and based on his stable lifestyle, we think that the Slauer court erred by not giving him a level 1 designation.
Okay, thank you.
Thank you.
We'll hear from your adversary.
Good afternoon. ADA Nicole Nichols for the Office of Darcel D. Clark. May it please the court. Defendant was properly adjudicated a level 2 sex offender, and a downward departure is not warranted.
So why shouldn't his stable lifestyle or his familial relationship to the victim constitute a basis for a reduction?
Your Honor, as the court noted, defendant in the 6.5, more than 6 years that he abused his stepdaughter, had a stable household. He lived in the same household. He had consistent employment during that period. That did not stop defendant's conduct in the first instance, and it gives no assurance that it will stop future conduct. We note here, Your Honor, this abuse occurred, as I stated, for more than 6 years. It started when the victim was 11 years old, ended when she was 17. It only ended because she left the home to attend college. During that more than 6 years, the defendant would awake the young child by touching her breasts, her buttocks, and her vagina. He frequently placed his penis in her mouth. The nature of the offense, its duration, and the harm that it caused certainly justifies the level 2 adjudication here. That defendant, as of course we had discussed, his background, his employment, does not mean he's a level 1 defendant. And the fact that his victim was female and a family member certainly does not justify a downward departure. And different types of sex offenders may offend at different rates does not mean that this defendant is a level 1 sex offender. His score on the RAI, which he does not contest, is an 85, render him a presumptive level 2. And nothing he argues here calls for a downward departure. And in any event, even if this presents a lower risk, the guidelines recognize that a defendant could be a lower risk, but where the harm that would cause, should they reoffend, is grave, that a higher risk level is warranted. And as discussed, if this defendant should reoffend, the harm would be grave indeed. Therefore, we ask that the level 2 adjudication be affirmed in it. Thank you.
Thank you.
Your Honor, just to clarify, again, I'm not here to diminish blameworthiness, but the standard is clear. Of course, there would be harm if anyone reoffends, but that's not the standard. The standard is whether we can view, based on defense counsel's evidence, whether it was mitigating, whether it was by a preponderance of evidence, and that the evidence was not accounted for in the RAI. And clearly, the intrafamilial relationship is not that of one which was accounted by the RAI. Again, 90% of the offenders who were studied did not reoffend based on an intrafamilial relationship.
In that one study, correct?
I'm sorry?
In that one study.
In that study, correct,
Right,
Your Honor.
okay. And do you agree, though, that there is a weighing between the seriousness of the offense and the alleged mitigating circumstances?
Absolutely, Your
And
Honor.
here, the seriousness of the offense is quite egregious.
Correct, Your
And the
Honor.
mitigating evidence that you're presenting has already been taken into account, and your argument is not enough.
It is not adequately taken
Okay.
into account. That's the language in Gelati.
Okay, thank you.
Thank you, Your Honor.
Thank you. Thank you both. The next case for oral argument is Children's Magical Garden versus Maron.
May it please the court, Andrew Goldenberg for appellant David Maron, and David Maron as president of the Horizon Group. Your Honors, a motion for sanctions must be denied if the movement cannot demonstrate that the alleged destroyed evidence actually existed. And here, respondents, they must prove that there were emails that were actually destroyed, that actually existed, and they failed to meet their initial burden. They haven't shown one scintilla of evidence.
Didn't they receive emails from other parties, like All-Star, Allstate, that did some work there, that were not provided to the court by you, but they were provided by the other side? Doesn't that indicate that they had them and destroyed them?
No, Your Honor. So those emails, first of all, are from a pest control company, a third party, that copied my client and another individual, Julio Morales, who was a day laborer. Those emails we submit are not relevant, not material or necessary to prosecute or defend any claim or defense in this case.
Wouldn't
They are emails.
Wouldn't they have been responsive to the demand for emails that concerned in any way 157 Norfolk? I mean, I think the demand was pretty broad. Why wouldn't those emails be responsive?
The demand was pretty broad. We objected to those demands.
But why wouldn't it have been responsive?
Well, they're not responsive because we don't have to produce everything that another party asks for. We need to produce things that are material and necessary to prosecute the claims or defenses in a case. And in this case, we're talking about an alleged attack that occurred in April of 20.
Did the court agree with you that those were not material or necessary?
That was one of the mistakes that the court made, Your Honor. But whether or not those documents were produced does not mean that they were destroyed. They were just not produced. And there's nothing in the record to show that documents from a third party about pest control eradication services were destroyed by my client. And they were produced by another party. I mean, the point here, Your Honors, is that the initial burden is, have you destroyed something that actually existed? And the crux here is, Judge Maisley found there are emails between David Maron and this guy, Julio Morales. Both of them testified that they never communicated with each other directly via email.
They called each other.
They talked to each other. They didn't text with each other. All we have on the record is the testimony of these two individuals saying, we have no emails. So how is it if it's the respondent's initial burden to prove through documentary evidence that something was actually destroyed, that my client has to go there and prove a negative? We have to prove a negative that something didn't actually exist. There's nothing in the record that indicates
Well, so let me just push back on that a little bit,
Sure, Your
right? You didn't issue a litigation hold to your client. You didn't tell your client, hold those emails, right? So already, we could never tell whether they were destroyed or not because you didn't ask your client for a litigation hold, correct?
Your Honor, that is correct. There was
So,
no
okay. So already, who knows whether they were or weren't? We can't tell because there's no litigation hold, right?
No, Your Honor, that's
So we
not
can't
right.
test the truth of the assertion, I didn't do any email, I didn't make any emails, because even if we searched, we wouldn't know, because no litigation hold.
Simply because litigation hold was not issued does not mean something actually
Well,
existed.
I'm not disagreeing with you, but you know, someone makes says, I don't have any, and there's no way to test it because of your failure to put in a litigation hold.
There is a way to test it, Your Honor. There's a way through live testimony, through an evidentiary hearing, through other sources of discovery. I mean, the point here is we don't have any activity beyond issuing a deposition notice to the defendant and to one third party. We provide a list of over 20 employees that they could have subpoenaed, they could have taken deposition notices of. They did nothing.
So are you saying that the court, what should the court have done? Should they have let this case go to trial, and at the trial let the jury determine whether or not they found that there were documents missing that?
So that's one alternative, Your Honor. So right here, we have the harshest possible adverse inference.
Well, other than dismissing your case, that would be.
Well, it is.
real.
It's in effect, it is a dismissal because what it is it's saying you are guilty. You have a guilty conscience. Whatever it is you destroyed, which, by the way, the inference here is you destroyed an email that you sent to Julio Morales saying, dump garbage on my own property because I want to get back at the garden in some way. I mean, the absurdity of that to begin with is it's just ridiculous. But if we're going to even accept that, at the very least, let's reach a middle ground. The middle ground is let's presume that evidence was lost. Let's presume that it was relevant and favorable to the garden, but allow the appellant to rebut the presumption, and then let the jury decide how they're going to sort it out. Are they going to draw that adverse inference or not? But to just say, you're guilty, it's like striking an answer, and that's a drastic remedy that this court seldom
So had the lower
employs.
court fashioned the adverse inference in form of a permissive inference as opposed to a mandatory one, would that have been acceptable to you?
It would have been acceptable if you reject my initial argument, which is the burden was not met.
Okay, let's hear from your adversary, and you'll have a few minutes in rebuttal. Thank you.
Good afternoon. May it please the court. Benjamin Burry of Blake, Marfonte, and Olds for the plaintiff responded.
Oh, go ahead.
Why wouldn't it have been more appropriate for the court to issue a permissive inference instead of a mandatory one, and to let the jury decide?
Well, defendant intentionally destroyed evidence during ongoing litigation.
What is your evidence of intentionality?
He admitted it in the deposition.
He admitted that he destroyed certain documents related to 157 Norfolk, but that doesn't mean that they were relevant.
Well, we presented him with emails, some of the emails we recovered from third parties, and he said, yes, this is probably a document I destroyed, and I can tell you if I got it today, I would destroy it.
Were they relevant to the issues in this particular case?
Absolutely. They concern access to the property during the time in question. And beyond the 2 emails that Julio Morales sent to David Maron that we recovered, there's hundreds of other emails. We cite a number of them, pages 39 to 40 of our brief. These are emails to which David Maron is a party, some of them, and they include things like no one can access the property unless David Maron as owner approves that access. That's highly relevant.
Even if they had to go to Mr. Maron to get access to the property, does that prove the next step, that he actually told them to dump this garbage onto the property? Isn't that another step that would have to be proven in order to?
Well, the standard for the court is whether defendant has demonstrated that these are not relevant. So it's a relevance question, and it's certainly relevant. So that for that reason,
Yeah, but it's not just whether they're relevant, it's whether they're relevant and you can't get the information from any other source. So why not just take his deposition and say, could anybody get on the property without your approval? Right? You could get that information exactly the same way by taking a deposition, correct?
Well, we tried. We took David Maron's deposition. We took Julio Morales.
And so what do we do with the parties' statements that they didn't email each other? So there's nothing about this issue.
It completely undermines their credibility because we have evidence that they did email each other. Julio Morales sent those emails to David Maron. Sorry?
What evidence do you have?
On page 42 of our brief, we provide 2 examples of emails that Julio Morales sent from his email with the name...
On this subject? On the
subject of access to the property. And beyond these emails, there's also the question of the business records.
Okay, so there's you're saying that you don't believe their credible evidence, their testimony, right? So is it appropriate for the trial judge to make a credibility determination in that way, or why not just send it to the jury?
The question is whether the 3 elements of spoliation have been met. Duty to preserve has been met. He had duty since 2014, 7 years with no litigation hold, no preservation.
That there is actually something there to preserve, which they say is not, and you say that their testimony is undermined by other evidence, so someone would have to actually make a factual finding about that, correct?
I'm not sure I follow.
Okay. The parties you are seeking to have an adverse inference again, they both say, we didn't email each other about this subject of throwing garbage and other stuff onto your property, right?
Right. And to be clear, Julio Morales said he never even heard of David Maron.
And you're saying, I don't believe that because there's circumstantial evidence that they would have done that.
Well, there's direct evidence that they did.
So with respect to that issue, that's a factual issue that somebody has to decide. Credibility, right?
There's direct evidence that they did email
about
with each other.
Right.
We have them, we cite them, and they're in the
Two
record.
different views of it.
And if I can introduce some of these other documents that he destroyed.
I'm not saying you don't believe their testimony, and you say there is circumstantial evidence that undermines it. I accept that. But the question I have for you is that means that someone has to make a factual determination on that issue, whether they're telling the truth or there are emails and they're lying.
I think the jury is instructed that evidence was destroyed and that the destroyed evidence would have indicated the following.
So that is what I am saying. That is a factual finding based on disputed facts, right? You've gotten a charge on facts that are in dispute.
For example, a key piece of evidence he does point to, the defendants point to, is this photograph taken by Julio Morales. Julio Morales testified that that photograph was part of a text message chain, that when he's hired to do a job, he has a text message chain with the person he works with. He takes the photographs, he text messages them, says, I finished the job, here's the proof, here's the photos. That text message chain has been deleted. It's been destroyed. We have just the photo with no metadata. And so he seeks to use the photo to say, well, this shows the completed work, nothing more was required. And the fact that we've deleted evidence of who the other workers were, what they did, text message chain that was a part of, is irrelevant. And that's prejudicial, and that's what the adverse inference cures. Thank you, Your Honor.
Okay. Counsel, you have 2 minutes for rebuttal.
Thank you, Your Honor. So,
why don't you start with the photo?
The photo? Yeah. Right. So I believe there's a photo that was texted. I don't know of the testimony where the person said, I deleted everything else on this photo. Sending a photo from Julio Morales to, I believe, Oren Ziv, which was his connection, again, doesn't establish any direct communications, electronic communications between David Maron and Julio Morales directly. What we have, again, are pest control emails that have nothing to do with this alleged attack. They have to do with periodic servicing of pest eradication on a vacant lot, which would have no documents whatsoever because it's a vacant lot, has not been developed for decades. There's nothing to produce here. And so it goes to your point, Judge Scarpello, it's a credibility determination.
So what do you, there is a photo that was...
Yeah, there's a photo.
And how do we know there aren't 8 photos and only one of them was produced?
Because that's what Julio Morales said. This is what I have.
So that is my whole point, right? That could be a suspect statement. Somebody's got to make the determination.
Let it be a suspect statement and let a fact finder...
At a minimum, you have to have a permissive inference. You have to put it before the jury and have a permissive inference because at a minimum, there's a question of fact there.
Well, I'll take that if I'll take the permissive inference versus the worst
Better than the one you
I would
got,
prefer
right?
that the court reversed everything because it goes back to the initial burden of proving something actually existed, and there's nothing in the record of direct communications.
Because you didn't put a litigation hold on.
Let's think about the absurdity of this. Let's think about, and this goes to your fact, the disputed fact. The absurdity of this is that someone is going to tell another person, dump garbage on the property I own because I want to get back at the Children's Magical Garden. It's absurd. And this is all they have here. And they're trying to rest on a sanction. Let it go to a jury. Let it go to a fact finder. Thank you, Your Honor.
I'm sorry, did I interrupt you? I didn't mean to.
Okay.
Thank you so much.
Thank you both. The next case is Knight versus Ammon. Hey, Julio, you got it.
Good afternoon. May it please the court. Mary Azaretto for the appellant, Ammon and Whitney. Erection, demolition, repair, alterations, painting, pointing, and cleaning. Those are the protected activities under the labor law. The act of turning a key to check if the water main valve was on does not fall within one of these protected activities.
This wasn't an ordinary key, counsel, was it?
The size or the weight of the key is irrelevant to this determination. Plaintiff here didn't fall.
Wasn't the use of the key essential to the next step of the construction project?
It may have been, but that...
So why isn't there at least a question of fact as to whether this is part of a construction project and we should not grant summary judgment either direction at this point until there's been more discovery about whether or not it was necessary, how this fit into the rest of the construction project?
Because regardless of, I'm sorry, I lost my train of thought. The bottom line here is that the size of the key, the weight of the key, it really has no bearing on the facts of this
Well, how do we, the question is, how do we know that at this stage? And wouldn't it be better to deny summary judgment and go ahead to have discovery about whether or not this was an essential part of the construction project, or whether it was, since our own decisions say we shouldn't look at a fact like this in isolation?
Because plaintiff didn't fall because of the key. Plaintiff didn't fall because the key was too heavy or the key was too big.
Right,
Plaintiff
he
didn't
fell
fall at
because
all.
what he was standing on in order to operate the key was insufficiently sturdy to prevent him from falling while operating the key, right?
There is no evidence whatsoever in the record that there was anything insufficient about the boarding upon which he was standing. In fact, he didn't even fall. All he testified to was that the key popped off the nut and he jerked his body. There's no indication that he fell whatsoever. There was anything wrong with the flooring.
Well, but wasn't there evidence that his jerking his body was to prevent himself from falling into the hole, into the excavation hole several feet below?
The bottom line is that even if it was part of a larger construction project, it's still under the well-settled law must fall within one of those categories. And the only ones that could arguably fall in here is either altering or repairing. It wasn't repairing because there was nothing wrong with the water main system, and it wasn't altering because they weren't changing it. And perhaps the most significant thing I need to point out to the court is that when you're determining whether or not an act falls within a protected activity, it can't be done in a vacuum. It has to be done in the context of what the overall purpose of the labor law is. And that is to provide adequate...
There I would agree with you, counsel. I agree we have to look at the overall purpose, and that's why I would think that we need more facts in order to determine that than what we have now.
Respectfully, Your Honor, the only facts we need are the two admissions that plaintiff already made at his deposition. Depositions were conducted in this matter. This is not a preliminary motion for summary judgment. In the record, at page 93, plaintiff admitted that there was no protective equipment he needed to perform his task of turning a key that he did not already have. Furthermore, in the record at page 101, he admitted he was unaware of any safety equipment that would have prevented the accident from occurring. Therefore, these admissions make clear that the overall purpose of the labor law would not be advanced by considering this ministerial act of simply turning a key to be a protected activity.
But those statements don't go to the issue that you and I have been discussing, which is whether or not this is, his actions were taken within the context of the construction, or whether it was pure maintenance.
I believe that they do, because it shows the fact that this act was nothing more than a routine ministerial task, that there would be no kind of protection that would even exist.
I mean, this is the plaintiff answering the question, was there any type of protection? But that doesn't mean that there wasn't any type of protection, even if the plaintiff was not specifically aware of it.
Well, it's plaintiff's claim that is the heart of the appeal here, and if the plaintiff himself is admitting there was simply nothing that could have been done to prevent this, there was nothing that I needed that I didn't have, then that then and there is sufficient to warrant dismissal of the Labor Law 240 claim. I'd also want to briefly point out, with regard to the Labor Law 200 claim, that appeal was not actually perfected by plaintiff's counsel. It was inappropriately included in this record. Therefore, we would ask the court to not decide it. As to the Labor Law 241 issue, the argument is pretty clear. Unless there are any questions, I'd be happy to rest on my brief on that issue.
Okay, you'll have a couple minutes in rebuttal. Thank you very much.
Thank you.
Good afternoon. May it please the court. Lee Eskenazi from the Grandelli firm for the plaintiff respondent, Clayton Knight. I'd like to point out a couple of things that my adversary said that she was correct about.
You would address why we should conclude that this was part of a construction project as opposed to just turning on a water valve.
Sure. So this was a very complex project that had been going on for more than a year prior to Mr. Knight being called down. And the reason he was called down was at the direction of the general contractor, Triumph Construction. They asked Ammon and Whitney, who's
Is there anything in writing in the record showing why they were called down there?
They were called down there. There's testimony from the Triumph witness as well as the Ammon witness that in order to make sure that the new water valve system would work and function properly, they needed to check to make sure that the interplay with the valve could be used to turn off the water and control pressure.
Is that a
and the whole
contractual
project.
Obligation?
I'm sorry, Your
Is
Honor?
that a contractual obligation?
It was part of Triumph's work and Ammon's work to make sure this got done. The way that they would do that is to submit a written request to the city DEP, who my
and then they send
client
out
is
the
an
plaintiff.
employee of. And they submitted that written request. In regards to the work that was done, they sent 2 construction laborers down, including my client, as well as a supervisor, to make sure that this work could be done
Wait,
properly.
when you
in
say
conjunction.
construction workers,
You've just referred to a written request. Is there a written request?
Yes, the
in
testimony is
No,
from,
is there a written request in the record?
I don't believe the written request itself made it into the record or had been disclosed prior to the Ammon and Whitney motion for summary judgment, which was made pre-note of issue. But Your Honor had correctly or incorrectly asked whether or not there was an issue of fact that should be resolved by a jury or with further discovery. However, that's simply not the case here. There's not an issue of fact as to whether or not the safety devices were adequate, whether or not this work was ancillary.
Well, what about
It's undisputed that it is.
counsel's claim that I asked her about, that your client said he was not aware of any type of safety device that would have helped the situation? I mean, you're the plaintiff. If you can't specify some type of safety device that could have helped your client, how does that fall within the labor law?
Under the labor law, it's not incumbent on the worker to know all the available safety devices that should have been provided to him. Here, what happened is they have an unguarded excavation without any rails, without any safety system. He was not provided with a secure platform or anything to stand on beyond the top of 2x4s, which were being used in a vertical fashion to shore the excavation. So you're talking about he had a matter of inches, 2 to 4 inches to stand on while turning a 6-foot key that required special work, another coworker to do, and a supervisor to supervise.
So
This was all being done under the
There was some
observation.
discussion that the way that he had to operate the gate on the date was not how he usually operated the gate. Usually the gate would be on solid ground, not in an excavated area, and that he would be above the gate. What import does those facts have to this case?
That's the violation of Labor Law 240 right there. The fact that they did not provide him with solid ground or somewhere to properly stand while he had to perform this work, which was ancillary to the construction project, which all the case law from the First Department, the Court of Appeals.
Does this construction project have proceeded without this test?
No, and that's undisputed in the record. This was something that Triumph said was critical to start to the next phase. They were called down overnight to do this so that work could resume the next day. If they did not appear that night, the work on this part of the project could not continue.
so let me ask you this, 2 questions. One, your client is a DEP guy. He's not hired by anybody. None of the construction workers hire him. None of the he's not a general contractor, he's not a subcontractor. He's a DEP guy, correct?
Correct, he is employed
And
by DEP.
also, he has a 200 claim for, no matter what, he's saying it was negligent, you set up this bad space for me to work, correct?
Correct, well,
So the question is really just, is he a 240 subsection 1 guy, which would be which is a particular person, or does he have other protections like 200?
Well, the 200 wasn't that dismissed by the court?
The 200 was dismissed, and I would contend that it was erroneously dismissed because the court
but
applied the wrong
Expect
test.
your appeal on that.
Well, we had
So
crossed.
we can't reach, how can we reach it, given that you didn't?
It was a procedural issue where, and if I may answer your question really quickly, even though my time's up, we cross-appealed on this case. The defendant asked for 2 enlargements of time to perfect their appeal. We believed that our time to file a cross-appeal would go with their extensions. However, we were informed at the time of filing it wasn't. We did make the arguments that we made in the lower court that this is not a means and methods. This is a dangerous condition. And briefly, I just want to mention the 241 subsection 6 argument. There's nothing in the record that shows, other than misstatements of law by the defendant, that 23-4.2H does not apply to this case. It has to do with an unguarded excavation, not merely work within the excavation, which is the problem here, because there was an unguarded excavation and my client did not have a proper place to stand. He was not protected under that industrial code section, which could give rise to liability under Labor Law 241-6.
Okay.
Other than that, I'll rest on my brief, Your Honors.
Okay.
Thank you.
Counsel, You have a requested minute for rebuttal.
Thank you, Your Honor. As to the 241-6 claim, I would just point out that if you look at the deposition testimony of the plaintiff, there is no evidence which shows that the reason that he injured himself was because he didn't have a good place to put his footing. He didn't lose his balance as a result of that fact. There is persuasive cases, they've been cited in the brief, which address this particular industrial code provision, which hold that it was intended to apply to individuals who are not necessarily performing tasks there, but more along the lines of passerby, so they would be aware of the excavation. Here, he was not only aware of it, he was working in it. And even if it did apply, there's no evidence whatsoever that the shoring was improper, and that's what would be required in order to find a violation. Thank you.
Thank you. Thank you both. The next case for argument is Zeitlin versus Cohan.
Good afternoon, Your Honors. May it please the court. My name is Justin Kelton, and I'd like to introduce counsel admitted pro hoc vice to argue this appeal, Joseph Oliveri of the Bar of the District of Columbia.
Okay. Thank you. Good afternoon.
Good afternoon, and may it please the court. Joe Oliveri on behalf of the plaintiff appellant, Jide Zeitlin, who's with us in the courtroom today. Your Honor, this appeal in this defamation case presents two straightforward questions in the context of New York's somewhat complex anti-SLAPP statutory scheme that I'd like to address today. First, what is the plaintiff's burden of persuasion for alleging actual malice at the pleading stage under the anti-SLAPP statute? And second, did Mr. Zeitlin satisfy that burden? The Supreme Court answered the first question by holding that the statute requires a defamation plaintiff to establish by clear and convincing evidence actual malice at the pleading stage. But in doing so, it conflated two distinct portions of the anti-SLAPP statute. On the one hand, you have New York Civil Rights Law, Section 76A. That speaks to a plaintiff's ultimate burden and says that damages cannot be recovered unless actual malice is shown with clear and convincing evidence. However, at the pleading stage, it's CPLR 3211G that governs. And what CPLR 3211G says is that a plaintiff bears the burden of demonstrating that a cause of action has a substantial basis in law to avoid dismissal. So the operative question is, what is a substantial basis in law? And this court and the Second Department have answered that question. It is, as the defendants note, an elevated standard above the ordinary 3211A because the burden is now put on the plaintiff to show that his cause of action has merit as opposed to the burden being on the moving party. What is the burden? This court has said, somewhat amorphously, that a claim has a substantial basis in law if it has such relevant proof as a reasonable mind may accept as adequate to support a conclusion. Now, subsection G of 3211 has not been addressed by this court, but it has addressed identical language in subsection 3211H, which also requires a substantial basis in law. Analyzing that language, the court said that under this standard, a plaintiff need not demonstrate that a claim is supported by a preponderance of the evidence, much less clear and convincing evidence. That's the Castle Village case, 5880 3rd 178. The Second Department has said the same exact thing in the Golby case that defendants cite in their brief that says under this standard, the plaintiff must deduce allegations and evidence that demonstrate the existence of triable issues of fact. Here, however, Supreme Court conflated Section 76A of the Civil Rights Law with CPLR 3211G, and so have some lower court decisions, including the Torres case, which the court cited. Torres quoted 3211G as imposing a clear and convincing evidence standard. That's not in there. That's in the ultimate burden section.
So, counsel, let me just say that assuming that we accept for the purpose of your argument that the clear and convincing standard is not on the pre-answer motion to dismiss, what are your actual malice allegations that would even survive even this, a substantial basis in law?
Absolutely. So that brings me to the second question. I appreciate the transition. We have here both direct and circumstantial evidence of actual malice. What Supreme Court did is it looked at 3 paragraphs in the brief in each of the counts and said this is only conclusory because you're just reciting the legal elements. It didn't look at the other allegations. It didn't look at Mr. Zeitlin's affidavit. Here, perhaps most directly, direct evidence of actual malice, Ms. Raymond gave the defendant a copy of a 2009 email to a Senate staffer in which she said that she was aware of Mr. Zeitlin's identity before, before any romantic relationship.
And so wasn't there a link?
I'm sorry.
There was a link to that, correct, in the article?
That's right, there was a link to that.
And isn't your claim of actual malice undercut by the fact that the article stated that the relationship between Mr. Zeitlin and Ms. Raymond was consensual?
So buried in the article, there is the statement that Ms. Raymond...
I didn't think it was buried. I thought it was pretty visible.
Well, if you look at the article itself, which begins on page 50. Yes, Your Honor. As a matter of speaking, if you look at the article itself, it begins with this statement that Mr. Zeitlin used deception to lure Ms. Raymond into an unwanted romantic relationship. Sure, later on he says that Ms. Raymond in the email says it was consensual, but throughout the entirety of the article, it's a focus on deception. It's a focus on these other allegations that he threw a stone or a brick through the window of her car, and that...
But counsel, it also includes his denials, right?
It includes a denial, and the law is clear that just because a defendant prints a denial doesn't absolve it of actual malice. Here, don't forget, we're at the pleading
Well, here the defendant printed both sides.
He said the defendant printed that Mr. Zeitlin denies these claims. However, he's still publishing the claims, still giving air to them in the context of a story that focuses on scandal, on alleged deception by Mr. Zeitlin. So here at the pleading stage, I'm not saying that all of the evidence goes one direction. Your Honor is right. There is evidence that could cut both ways. But at the pleading stage, Mr. Zeitlin has pled and offered documentary evidence that shows various red flags, various indicia of actual malice that courts have held are capable of sustaining an inference of malice. And don't forget, with actual malice, we're talking about the defendant's subjective state of mind, evidence that's generally in the defendant's exclusive possession. So a plaintiff is handicapped before discovery. So that's why circumstantial evidence of the various types that we list in our brief, coupled with this direct evidence, should be more than enough to get to discovery. It'll be a different question whether or not how the case ultimately comes out down the line, but pre-discovery, at the pleading stage, we submit that there have been more than sufficient indicia of actual malice. I see my time is up.
Okay, you'll have a few minutes on rebuttal, so thank you very much, counsel.
Good afternoon, and may it please the court, Jay Brown from Ballard Spar for the defendant, William Cohan. The subject of whether the anti-SLAPP statute applies in this instance has not come up thus far in this argument. That is, whether the publication at issue addressed a matter of public concern. Mr. Zeitlin argued extensively in his briefs that it does not apply here because this article addresses, or the challenge statements.
Counsel, can I ask you an initial question? Do you agree that the judge, do you believe that the judge was correct in applying the clear and convincing standard to assess the adequacy of plaintiff's pleading? Or should he have applied a lesser standard?
Your Honor, we believe the judge did the correct thing, but described it inaptly.
What are you claiming he actually did?
In all seriousness, Your Honor.
I know you're serious.
As counsel pointed out, this court and others have said that on a motion to dismiss in this context, the plaintiff's burden is to allege facts that would be sufficient for the ultimate fact finder to make the required finding. And in this case, the required finding on actual malice is that there was clear and convincing evidence that the defendant lied or suspected he was lying. That is the definition of actual malice. And so at the pleading stage, as is widely recognized with respect to pleading actual malice in the First Amendment context, but under the anti-SLAPP statute's substantial basis burden, what that means as a practical matter, which is cases are cited in our brief as well as the brief of the amicus in this case, what that means as a simple practical matter, correctly described, is that the plaintiff has the burden of alleging facts that if proven, would entitle a jury to conclude that actual malice was established by clear and convincing evidence. So it is not that the plaintiff must come forward with actual evidence of clear and convincing type, but must allege facts that, if ultimately proven, would be a clear and convincing case of actual malice. And here, there are no such allegations. The judge and the several court opinions cited by the trial court judge and the several other opinions unfortunately talk about proof of actual malice at the motion to dismiss stage. But as we point out in our brief and as the amici point out in their brief, it is allegations of fact sufficient to constitute clear and convincing evidence of actual malice that is required here. And here, most of the allegations go to the point that Mr. Cohan possessed information that contradicted Ms. Raymond's description of events. And as one of your honors has already pointed out, indeed, he included that information in the article. I hope and believe that your honors, if you have not already, will indeed read the article from top to bottom, and you will, I think, agree with me that it is a biographical summary almost entirely of pre-existing public controversies regarding this public figure, Mr. Zeitlin, who has both an extraordinarily positive life story and several negative occurrences in his life, one of which includes Ms. Raymond's submission of her email to the Senate while his nomination was pending. And I will just, as a footnote here with respect to the alternative ground for affirmance of the fair report privilege, where the plaintiffs have challenged whether this is actually a report about an official proceeding, I will note that the Senate confirmation proceeding was ongoing at the time Ms. Raymond submitted her email. It is undisputed that she submitted her email. And for that reason, this case is sharply distinguished from the ones cited by Mr. Zeitlin in his papers, in which a person out of the blue submits an allegation to a law enforcement or other governmental agency and asks them to do something about it, and there is no proceeding pending or initiated. Here, there was already a legislative proceeding pending to which the email submission was relevant, submitted during the pendency, and for that reason, this is a
Could you discuss how we should take into account defendants' reliance, if any, on the Latman article?
Yes. Well, are you referring to the one that originally published the allegation? Yes. In the Forbes-related publication. That goes both, of course, to the defense of the republication privilege, but also goes strongly to defeat any allegation of actual malice, precisely because this very allegation was previously published in a major news publication. And Mr. Zeitlin does not dispute, he does not deny that he never sought a correction, never sought a retraction, or never took issue with that original publication. And not only does that afford Mr. Cohan a privilege to rely on that earlier publication, but the fact that there was no challenge to it, it literally undercuts any allegation of actual malice on his part. And with respect to the other claims of actual malice, the lower court correctly found that each of them is conclusory, and even under ordinary 3211 motion to dismiss standards would be insufficient to sustain the claim. But whatever is the correct articulation of the standard to be applied under the higher substantial basis test, it is clear that from the record that the lower court correctly held that plaintiff had not alleged facts that, if proven, would show by clear and convincing evidence that Mr. Cohan knew he was lying when he published these materials, or strongly suspected he was lying, but went ahead and published them anyway. He provided the hyperlinks to multiple documents, including not only the Senate email, but some of Mr. Zeitlin's own publications, precisely so that readers would see the original source materials themselves and be able to draw their own conclusions. And that, the law says, is the antithesis of actual malice. Thank you.
Thank you, counsel.
So I hope to focus most of my rebuttal on the actual malice issue that, Your Honors, I've asked a lot of questions about. Just with regard to the fair report privilege, record 53 and 57 show that it was never, no one received, the Senate staffer doesn't remember receiving it, and the allegations didn't play any role in the proceeding. With regard to actual malice, at the pleading stage, before discovery, a plaintiff can't know the subjective facts that are in a defendant's mind. So what they have to do is plead circumstantial evidence that, considered in the aggregate, can raise an inference and entitle a plaintiff to discovery. In addition to the fact that the email from Ms. Raymond shows that she was aware of Mr. Zeitlin's true identity before the romantic relationship developed, and to be clear, publishing a false allegation is not absolved by the fact that you also print that the subject of that allegation denies it. I would note the Condit v. Dunn case from the Southern District of New York talks about how the First Amendment does not absolutely protect a speaker who republishes false statements but disclaims awareness of their truth. Similar here. What is the circumstantial evidence in addition to that direct evidence? Airmail, to whom Mr. Cohan had shopped this story about Mr. Zeitlin before publishing it in ProPublica, refused to publish it because they found that the allegations could not be corroborated. Similarly, the Foundation for Financial Journalism refused to publish it. ProPublica was all too willing to do that. To publish it. Mr. Cohan also had reason to know that Ms. Raymond was a biased or non-credible source. The email that we've talked about from Ms. Raymond...
Excuse me, many of the things that Ms. Raymond said, he later corroborated, correct? That they, for example, had a sexual relationship.
Mr. Zeitlin did not deny a romantic relationship with her. The denial is the fact that Ms. Raymond knew who he was. He knew he was G. Zeitlin before that began. In that email, Ms. Raymond indicated a history of mental illness and drug abuse and extreme anger at Ms. Zeitlin, bias and facts that show that she might not have been a reliable witness that Mr. Raymond or Mr. Cohan knew about. I see my time's expired. Thank you, Your Honors.
Okay, thank you. Thank you both very much. We will take a good look at these papers. Thank you both. The next case for argument is O'Shea. Good afternoon.
May it please the court, Michael Horowitz for plaintiff appellant O'Shea. In this case, Mr. O'Shea testified that his foot slipped off the ladder, he went down to the ground below, he twisted his ankle, and he fell down. The circumstances of that are supported in a general way by a photo showing a messy ladder and by a photo showing a large area of mud, dirt, gunk, with only 2 boards to go over, and frankly, by Cozen's own witness, who says, yes, dirt and gunk and mud were always being tracked over because there were only 2 boards and there was lots of gunk. There's no contrary witness. There are 4 First Department cases that say that when a ladder is slippery, when a worker falls off a ladder that's slippery, summary judgment should be granted to the plaintiff. And I submit to you that those cases are dispositive. I submit to you that the legal technical arguments that maybe there was a ladder somewhere on site that they didn't know about, maybe he didn't complain about it.
There's no evidence that he was told to use the other ladder, right?
He was never told to use that. The truth of the matter
In fact,
is...
there's not even any evidence of that ladder even existed, right?
Right. The truth of the matter is the gentleman testifying saying, oh, at some point in time there was another ladder. His boss didn't know there was another ladder.
I mean, it also seemed to me the testimony showed that the one ladder was on the First Avenue side and one ladder was on the FDR side. Now, kind of knowing what that might look like, that would be a long walk to go use the ladder on the other side of the building.
Right, and
even if it were there, which we're not sure.
Right, we're not sure, and they could prove it. You know, the witness said there are daily photographs in a daily log. Right. They didn't put that in. So all of those arguments against those four previously decided first.
And what about the claims that the defendants made that maybe this was because the mud was all over his shoes and he didn't knock it off his shoes well enough?
Right. He knocked it off his shoes 6 flights earlier. He walks around the building down 6 flights. He's fine, and that makes magically all of a sudden his shoes are wet and what have you, when their own witness is basically saying, yeah, this was a
Well, didn't they say there was just mud, there was so much mud there was kind of no way of dealing with that?
That's what he said.
The way it was set up.
There's no way that the workers could walk past that without mucking up their shoes and mucking up the ladders. And again, they open the door to this by saying, well, it's a construction site, what do you want? Afterwards, they clean it up. You know, afterwards, they grade it out, they put gravel down, they make it so that this doesn't happen. Now, the trial court denied summary judgment under Labor Law 240 sub 1, claiming that the C3 created an issue of fact. First of all, there's no foundation for the C3. It's just annexed to the papers. No one says it's a business record. Even at his deposition, the plaintiff testified, look, that's not my writing. I signed it in blank, I gave it to Terrence. They don't put in an affidavit from Terrence or whomever. And quite frankly, just as a collateral point, if you look at the C3 and his signature and the writing, they are obviously different. There's no way that this gentleman wrote those things. But the larger point there is that it's not contradictory. I mean, the C3 at worst is a truncated version of the same facts, which under Marino and under Wazlewski by this court isn't enough. The first part of the C3, what were you doing when you were injured or became ill? And the answer is climbing down the ladder. That's what he said, okay? Then it says, how did the injury happen? While climbing down from the ladder, and I'm quoting directly, on the ground, I lost my balance from an uneven surface. As a result, twisted my ankle. That's what he said. When he hit the ground, he twisted his ankle. There's no contradiction. And even if it's not perfect, under Marino and under Wazlewski, the truth is it's a truncated version of the same. In both of those, the coworker says, well, the worker says he slipped. And the court said, well, what he said was the ladder moved and he slipped. It's not right in the tax code here. It's a truncated version of the same facts, of the same series of events. And that's not a contradiction. I think looking at the C3, not only is there no foundation, there's no contradiction, but insofar as it's not perfect, it is at worst a truncated version of the same facts, which doesn't create a material issue of fact. I would say, too, that even if there were an issue here on that, and there is none, under either 23.1D or 23.1.7E2, under either of those sections, even if he wasn't on a ladder, even if he was just stepping off, and that's not what happened, that would be a Labor Law 241-6 case. This was the only pathway to his work, even if you believe that's what happened. Even if there's no evidence of that.
Okay.
But even if you believe that's what happened, we should get summary judgment under that. They should have cleaned it up, as eventually they did.
Okay, thank you. You'll have a moment or two for rebuttal. Your defendant's third-party plaintiffs, cross-appellants, right?
Correct. Okay. And I'm going to stand on my opposition to plaintiff appellant's motion, and I'm going to defer to my colleague, Mr. Lawless, for opposition to that. Would the court prefer to hear from Mr. Lawless now and then hear my argument on my appeal? Or how would you prefer to do it?
Well, you can go ahead and speak to your appeal, and yes, you can speak to your appeal.
Okay. Good afternoon. My name is Peter Simon. May it please the court. I'm here to argue the appeal of a denial of my client's motion for indemnity against Cohan Construction. These issues have been raised, litigated 100 times, and I'm sure that the court has heard this issue multiple times. The language of the indemnity is arising out of. It is very broad-based. This court and virtually every other court has already found that when you have an employee who is injured during the course of his work, that triggers the indemnity. That is exactly what we have here. Cohan has conceded, as it must, that Mr. O'Shea was an employee of theirs, that he was in the course of his work, and that he was injured. Now, the one thing that they do argue here is that it was my responsibility as the owner and the general contractor to ensure the safety of the site, and it cites to my contract with the owner. What they don't cite to is their contract with me, where all of my safety obligations are devolved down to them, which is what happens in virtually every single construction case. Here, there is no question whatsoever. Article 15 provides that they have the responsibility to ensure the safety of their workers and the maintenance and the upkeep of the job site. Unless there are any other questions, I defer.
Whose obligation was it to maintain the ladder? Aren't you the owner of the, and general contractor?
I am the owner and the general contractor, yes.
So you don't have any obligation to maintain the ladders that the workers work on?
Article 15 of the contract between my client, Proceda Butts, and Cohan provides that it is their responsibility to ensure that all of the material and all of the equipment that is used by its employees is maintained and is safe.
Is there a different analysis if he's going to get coffee and not in the midst of the work at the time that he's injured?
No, there is not. The courts have looked at bathroom breaks, coffee breaks, cigarette breaks, people coming onto the job site, people leaving the job site, and there is no different analysis there.
But I mean, if you had any responsibility for this, you can't, he can't cover you for your own negligence.
He can't cover me for my own negligence, but any responsibility that I had was to the owner of the site. He then has the responsibility, Cohan has the responsibility to me to make sure that all of the equipment and material that they use is safe and maintained.
So what evidence do you put in about Cohan's obligation to control the job site ladder?
Article 15.
Just the contract that says, okay. And that ladder's several floors away from where Cohan is working, correct?
Yes, and it's being used every day.
And you're saying you have no obligation to maintain that ladder?
I have an obligation to the owner.
Right. So right, it could be solely your negligence that caused this accident, correct?
No, that is not correct.
Why is that not
Because
correct?
just because I have a contractual obligation to maintain something with another party doesn't mean that I can't then transfer that obligation to somebody else, a downstream party, if you will. So when an owner says to me as a general contractor, you owe me this, yes, to that owner, I have that responsibility. But when I take that obligation and I transfer it to another party that's downstream in my contract with them, I am no longer.
Even if you are you're saying even if you are solely responsible for the cause of the accident, you can transfer it down?
I'm not sure I'm following where
If you are the sole proximate cause of the accident, you're saying you can transfer your liability to another party under the indemnification provision.
I don't believe that there's evidence here that I am the sole proximate cause of this.
I don't know whether you are or aren't, right?
Sorry.
So to the extent that we don't know whether you are or aren't.
No, I think respectfully, Your Honor, in that circumstance, then as the sole proximate cause of something, New York says, I can't be indemnified.
Exactly. So if we don't know, if there hasn't been a finding as to who would proximately cause the accident, then why do you get indemnification?
At this point.
Because in this circumstance, Your Honor, I may have an obligation to the owner, but that obligation is then transferred to my subcontractor.
Okay, well, I think you've said that a few times, so let's hear from your subcontractor.
Good afternoon. May it please the court. Patrick Lawless for third-party defendant respondent Cohan. Proceedings counsel is incorrect in that the agreement between Proceda and Cohan transferred all the responsibility for the entire work site to Cohan. All it says is that Cohan was responsible for the materials and equipment that its workers used. The latter isn't that. The ladder was used by all workers at the site.
Who owned the ladder? Do we know that?
It was, I don't know who, I would say that it would be the owner in the GC. It was constructed, it's unrefuted that it was constructed by one of Proceda's other contractors, and that all the workers at the site that needed to access the building used that ladder.
I would think so.
Also, it's unrefuted that Proceda was responsible for the walkway leading up to the ladder, and there's issues of fact whether the mud that was allegedly on the ladder was tracked from the walkway or was it tracked from the work that was being performed. So under those circumstances, there are issues of fact where the Proceda
So
was...
it's premature is what you're saying for us to
It's
make that
premature. There's issues of fact whether they were the sole proximate cause, and that's specifically in the indemnification language. So as to the denial of the plaintiff's 240 claim, the C3 form, if you read it, it directly contradicts the story because it's not saying that he slipped on the rung of the ladder.
Is it authenticated?
The plaintiff admitted at his deposition that he signed it, and it also...
But he said he signed it, at one point he said he signed it, it was blank. They handed him and said, sign this, and later it got filled out and he never read it. That's...
He admits it's his signature.
Okay, but that's...
Also, the form states that by signing it, you affirm that all the information on there is true.
Don't you acknowledge that he testified that it was blank when he signed it? And that he never read it in a signed form?
He disavowed it at his deposition.
Okay, how did you authenticate the C3?
Through the plaintiff's testimony that he signed it.
Yeah, but
he
what...
said it was not signed, but if you're authenticating it through plaintiff, that's sort of ironic since he says that when he signed it, it was blank. So I don't see how that authenticates, I don't see how that authenticates the substance of the C3.
I think so because it contains two statements on it. It says that by signing it, he affirms that all the information is true, and it also says he acknowledges...
Maybe he shouldn't have signed it, but that doesn't change the fact that he testified that it was blank when he did.
But he also testified at his deposition that he did receive workers' comp benefits, he did attend the hearings, and he did have an attorney present, and that form was never changed during that entire process.
And what would have been the problem of producing an affidavit from Terrence that said, I filled this out and this is what he told me? I mean, then you take away the hearsay problem, but nobody did that.
But it's still a statement. It's still a statement against interest, and it contradicts his story.
Only if you get to attributing it to him.
Right.
And again, he's affirming that it's true by signing it. So he says that after the fact during his deposition to try and walk away from the comments that are on there. But it's as good as affirming that all the statements are true. So based upon that, the court properly denied summary judgment. And with respect to the labor law 241-6 claims, the court properly found that there were issues of fact requiring the denial of those claims as well. There's issues whether it was material that was integral to the plaintiff's work that was on the ladder, or whether it was mud tracked by other workers at the site. And also, this wasn't a work area, it was just a ladder that was being used as a method of ingress and egress. So based upon that, the court properly denied summary judgment. Thank you.
Thank you. Mr. Horowitz, you have a minute? Anything you'd like to say?
I would just say, in terms of intrinsic to the work, they were working 6 stories up, and there was a canopy over the ladder.
Can I ask you, what do you say to counsel's response that, yeah, it's a hearsay document, but he authenticated it by signing it?
Well, first of all, he authenticated that whatever was on there was true, and there was nothing on there. So what does that mean? And you still need a linkage between the words and and the plaintiff.
So you're saying someone had to authenticate that this is what plaintiff said to them, and there's nothing,
If they brought
it's
in
just a
someone, then
form.
that would be a question of fact. But I would also say that if you look at the words, and you look at Marino and those other things, there really aren't two stories. He fell at the ladder, and if you look at it, I think it's a at worst, a truncated.
Well, he said, since I have it here, I lost my balance from uneven surface. As a result, twisted my right ankle.
Yeah, he did, on the ground.
He didn't mention anything about the mud and the muck, which we were talking about afterwards.
Right, it's at worst. Just before that, it said, where did it happen? And it says, coming while on the ladder.
Down the ladder.
And then he says he lost his balance when he hit the ground. And that is much like Marino, where it says, someone comes in and says, oh, he slipped. He didn't say, oh, the ladder shook and he slipped. And the court says, well, that's not a contradiction. It's just a truncated version of the same fact. So even if it's admissible, I submit it's not a contradiction and not a basis on which to make it.
Okay.
Thank you very much. Unless there are questions.
No. Counsel, you have a minute also.
Thank you. The language triggering the indemnity is arising out of, resulting from, or occurring in connection with the performance of the work. Cohan has already conceded that its work as a mason involved mud, water, cement, all of which were on their shoes and which may have been on the ladder. At no point in time did I make an argument that my responsibility site-wide became Cohan's responsibility. Cohan's responsibility is for the areas in which it works. Article 15 of the subcontract entitled Protection / Safety and Accident Prevention / Construction Practices at sections 15.8, 1513, 1515, and 1521 all require Cohan to maintain a proper safety program for its employees, clean and maintain the area, the work and the area in which it is working, and fully comply with all OSHA and other applicable laws relating to the safety of its workers.
Okay. Thank you all.
Thank you, Your Honors.
Good afternoon. People versus Bueno.
Good afternoon, Your Honors. Katrina J. Myers from the Office of the Appellate Defender for Mr. Dennis Bueno. Mr. Bueno is serving 9.5 years for possessing heroin. That's 1.5 years beyond the statutory minimum. His sentence is 3.5 years longer than that of his co-defendant and supplier, Mr. Gennaro Lariano, who was sentenced to 6 years for the same exact crimes.
It seems that you did not give us all the information to compare, which, I mean, we don't have to do that anyway, or the courts don't always do that. There are different reasons, but we don't have any background as to why he may have gotten a different sentence, while Mr. Bueno, who also had a substantial violent criminal history, got the time he did. So how can we really even consider that?
I think Your Honor should take into consideration the gravity of Mr. Lariano's conduct and the information that we do know about him and his criminal history into consideration. So primarily, we know that Mr. Lariano was also sentenced for the same exact crimes back in 2012. So he also has a criminal history record.
Mr. Lariano wasn't a second violent predicate felony offender, was he?
That's correct. He was not. He was not. He had prior drug sentences.
Consideration?
I'm sorry, Your Honor.
Isn't that an important consideration for us in considering the sentence that Mr. Bueno got?
I think of course, Your Honors can take that into consideration, but I think comparing the sentences in terms to Mr. Lariano receiving the minimum term of incarceration and Mr. Bueno not receiving the minimum term of incarceration. Mr. Lariano had a previous criminal history record. His sentence is 3.5 years less than Mr. Bueno's. He was a large-scale trafficking supplier.
It's not an appropriate one. When you say it's 3.5 less, it is mathematically, but that's comparing apples to oranges because one's a violent predicate, the other one's not.
That's correct, Your Honor. However, sentencing Mr. Lariano to the minimum while
Now, that's a
sentencing...
different argument.
I'd like to make that argument, Your Honor. While sentencing Mr. Bueno to a 1.5 years beyond the minimum is not just. When you look at Mr. Lariano's conduct, it is clearly more egregious than what Mr. Bueno did in the instant case. He supplied multiple narcotics organizations around the city with large quantities of heroin. He was named in more accounts in the indictment than Mr. Bueno was. When he was arrested, the cops found over 1 pound of heroin and cocaine in his apartment. That's twice as much as Mr. Bueno. And the court should also note that the facts underlying Mr. Bueno's conviction are the fact that he was on the phone with Mr. Lariano and spoke with Mr. Lariano about the heroin that he received from him. Mr. Lariano provided him with the heroin that he is convicted of possessing. It is not logical for Mr. Bueno to be sentenced to a 1.5 years beyond the minimum when Mr. Lariano has served minimum for more egregious conduct. And Mr. Lariano is not the only co-defendant who received considerably less time. Mr. Bueno had a co-manager of the organization, Ms. Clara Prado, who was sentenced to an aggregate term of 1 year for albeit less severe crimes, but she had a similar level of culpability. She was also managing the organization. The detective who was in charge described the organization as their organization, hers and Mr. Bueno's. She separately directed street-level dealers and also interacted with Mr. Lariano on her own, saying that she was going to bring him money in exchange for heroin. This was all in the absence of Mr. Bueno and was going on separate for him. So Mr. Bueno is serving what amounts to almost a decade in prison for conduct that is very comparable to that of his co-defendants, which already contemplates, the minimum already contemplates his past criminal history record. And it is a sentence that is more akin to something that someone received for a crime such as assault or attempted murder. A reduction to the minimum, or even taking a little bit off to correct the disparity between the sentences, would be a just exercise of this court's discretion. And the appeal waiver in this case does not prevent the court from reaching this issue. The court was vague in terms of what it told.
And what are the extraordinary circumstances that would cause us to second-guess the sentencing judge?
The court should look at Mr. Bueno's sentence and step back and use its interest of justice authority to view it from the totality of the circumstances. This court's in a good position to analyze challenges of disproportionate and disparate sentences because it's based on the cold record of the case, and your honors see a multitude of sentences that come down from various criminal narcotics organizations. And if there are no more questions for me right now, I'll reserve the rest for rebuttal. Thank you.
Good afternoon, Your Honors. May it please the court. Connor Burns for the people. Just to begin, defendant's excessive sentence claim is foreclosed by his valid waiver of appeal. Justice Ross took care to separate the trial rights that he was giving up as a result of his plea from the appellate rights that he was choosing to waive. And the colloquy combined with the detailed written waiver made sure that he understood those rights, the right to appeal and what he was waiving. It made clear and was specific that he was giving up his right to challenge his sentence. And it also enumerated the 4 claims, the 4 challenges that would survive an appeal waiver. And the defendant, on the record, confirmed his understanding of the written waiver, that he signed it and that he assented to its terms. But in any event, defendant's sentence is not excessive and is fair and appropriate given the severity of his crime. And I would just like to correct the record. I know there was a discussion, the comparison between Gennaro Liriano and the defendant. It's based on our information that we have at the district attorney's office that this was Gennaro Liriano's first criminal conviction, and that therefore he was not sentenced to the minimum. He was sentenced 3 years above the minimum for second-degree criminal possession. It would be 3 to 10 years for a first offense, and he was sentenced to 6 years. Now, again, none of this is before Your Honors because none of this information was provided to you. But again, it's the information we have in our office that it was not that it was his first conviction. And again, as well, the evidence does suggest, again, this was a plea and then didn't go to a trial, so the evidence wasn't fully developed, but it does suggest the defendant was the organizer and the leader of this heroin distribution gang. He had street-level manager, multiple street dealers, as well as multiple stash locations. And in light of that, he did receive a very fair and lenient sentence when he was allowed to plead to the reduced count of second-degree criminal possession, as well as second-degree conspiracy, and he received 9.5 years. But I think when you look at that, he was charged in the indictment originally with first-degree criminal possession, which on its own, if he went to trial and was convicted, carried a 15 to 30-year sentence. He was sentenced to 5.5 years below that minimum on his current offense. So I think when looking at that, and he was also able to dispose of 4 indicted felonies through his plea deal. So I think all of that shows the leniency and the bargain that he did receive through his plea deal. And if there are no further questions, we ask that you affirm. Thank you.
Thank you, counsel.
Well, Your Honors, I guess I have a minute. I would first like to address counsel's new information that Mr. Liriano was not sentenced prior to, I believe it was criminal possession of a controlled substance and conspiracy. This is the first I'm hearing of it, and Your Honors can look at the criminal system and the court's information to see that that conviction is real and on his record, and whether or not the district attorney's office properly used that information to enhance his sentence is on them and out of my knowledge. I will say that Mr. Bueno was not the leader of the organization. If anything, he worked on par with Mr. Liriano and Ms. Prado to direct this organization and get business done. Your Honor should look at the telephone call that Mr. Bueno placed with Mr. Liriano, where he updates Mr. Liriano on the progress of his narcotics operation. That's not a call that someone would have with an uninterested party or another peer. It's someone who is wanting direction and who is looking for approval and needs to update someone on the goings-on of their business. And the appeal waiver, if I may quickly, mischaracterized the right to appeal. It was overbroad in this case. The court gave a very broad description of what it was, said it was the right to appeal from a higher court. And as the court mischaracterized the right to appeal, the written waiver did not cure it, and it is no replacement for the court's on-the-record explanation of what the right to appeal is. Thank you.
Thank you, counsel, very much. Have a good afternoon, both of you. The next case is Mira versus Argus Media.
Good afternoon, Your Honors.
Can you put the mic?
Good afternoon, Your Honors. May it please the court, Leslie Moore Mira, pro se appellant. I will readily concede from the start that my adversary's papers have been more artful, but the substance and interest of justice and law weigh on the appellant's side. If you've read some of the papers, serial anomalies and apparent conflicted courts denied fair and fundamental hearing of this case. In direct contradiction of federal and state rulings, U.S. versus Ossinger, U.S. versus Sayer, there are a number of state cases that would contradict the federal court's findings that the facts and allegations in Mira versus Argus Media were frivolous or inherently incredible. Consistently in both the trial court and adversaries failed to prove that there would be prejudice to reverse and to remand to the trial court. There would be no prejudice in remanding and reversing the trial court's opinion here. The defendants had been familiar with the facts and allegations since 2015, and one could reasonably infer that the corporate that the in-house lawyer for Argus Media, who was later identified as a defendant, would also have been informed, as well as Jim Kennett and Michelle Gasser. So there may have been some procedural error on my behalf, but I believe it's non-fatal to the egregious facts and allegations and circumstances. And I would ask the court to consider the totality of the circumstances here, and also to consider even that while there may be some statute of limitation questions, that given the totality of the facts and circumstances, and as we have come to see in other cases, such as U.S. versus Ossinger and U.S. versus Sayer, that this case does meet the elements for New York Penal Code 250.55, and there's sufficient case law, Leader versus Maroney, and CPLR 2005 and CPLR 304, that, and Lichtman versus Sears Roebuck, that support the appellant's request here, that this case be remanded to the lower court in the interest of justice. Thank you.
Thank you very much. You have a couple minutes when she finishes.
Okay. Any questions, Your Honors?
If we did, we would ask.
Okay. All right.
We're not
Fair
shy.
enough. Thanks.
Thank you. Good afternoon.
Good afternoon, Your Honors. And may it please the court, Jean Baron-Holtz from Foster Garvey for the defendant's respondents. So this case is about, this appeal is about whether Ms. Mira's claims are time-barred, and they are. They are time-barred because her complaint arises out of her May 2014 termination from Argus Media, and so the normal statute of limitations on her state and city HRL claims, her business tort claims, her negligent and intentional infliction of emotional distress claims, those statutes are all expired. However, because there was a timely filed prior federal case under Section 205A of the CPLR, the claims could have been brought in state court after the termination of the prior federal action.
So when did the statute begin to run again?
So the 6-month period started to run when the prior federal action was terminated. That happened either on September 25th, 2018, which is when the Second Circuit dismissed the appeal as frivolous, or at the latest on January 18th, 2019, which is when the petition for rehearing en banc was denied by the Second Circuit. And so even if you start the 6-month period from the later of those two dates, which is the January date, then the 6-month period would have expired in July 2019, which is well before the complaint was filed in this state court case, and let alone served, which also has to happen within that 6-month period under 205A. And then the reason why I bring that up is because appellant has relied on CPLR 306B for extensions of time to complete service. However, this court has made clear that CPLR 306B and CPLR 205A operate independently from one another. So while CPLR 306B deals with the 120-day period to serve a complaint after it's filed, and does allow the court to exercise its discretion in certain circumstances to extend that 120-day period, there's no such discretion when it comes to the 6-month period in 205A. And as this court explained in the Pine case that we talk about in our brief, the 120-day period in 306B doesn't negate or nullify the requirement that is explicit in 205A, that the complaint must be filed and served within the 6-month period provided for under that statute. If there are no further questions, I will rest on my brief.
Okay, thank you. Ms. Mira, you have a little time for rebuttal, if you'd like to respond.
The Pine is, as I understand it, the Pine case, which has been upheld in this appellate division, I don't believe that's gone before the Court of Appeals. I don't, there may be a split question there, but as I understand it, this is the one appellate division that has upheld or has cited Pine. I would like to add that there's been a question of continuing violations, and to the degree that the defendants have been complicit in a sort of nexus of complicity with continuing violations that are remarkably similar to conduct during my employment at Argus Media. And I would like to end on a couple of things. One, the defendants have, the appellees, excuse me, have discussed their, in detail, the belated, in their view, a belated service. I did seek, soon after filing my complaint in 2020, I had informed corporate counsel of Argus Media of the action, and they said that any reasonable further extension requests that they agreed to. So they were in fact informed. And final, I'd like to say just in a very from the appellant's heartfelt perspective here, that in a letter to from counsel to the court in February, the counsel said that our client is not interested in offering Ms. Mira any money. I would just like to say that throughout I have sought accountability and acknowledgement for egregious conduct. Thank you very much, Your Honors.
Thank you. Thank you both very much for coming in this afternoon. Thank you, Ms. Mira. The next case for argument is 829 Greenwich Street versus Slauer. Good afternoon.
Good afternoon. May it please the court, my name is John Moore and I represent Appellant 829 Greenwich Street, LLC. This court should reverse the dismissal of plaintiff's suit because the motion court disregarded controlling law and improperly resolved factual disputes against plaintiff on a motion to dismiss. The question here is whether a home purchaser can justifiably rely on bargain for representations after the seller of that home actively conceals true facts regarding extensive leaks and mold in the home. Contrary to the motion court's holding, neither the home inspection report nor the disclaimer provision in the contract preclude justifiable reliance as a matter of law.
Well, how do you address the relevance of paragraph 12 of the party's contract of sale, in which the buyer disclaimed any reliance by saying that the plaintiff accepted the house as is?
So 2 points on that, Your Honor. The first is that the disclaimer provision does not apply where the facts at issue that giving rise to the claim were peculiarly within the knowledge of the seller, which is what we've alleged happened here.
But the thing is, you did, as most buyers do, have an expert go in, have an inspection done of the premises. Now, I know they did not take apart the whole house to do the inspection. That would sort of not be very common. But they did give you a relatively substantial inspection report back that should have put you on notice, put me on notice, that there was some water damage throughout this home.
So let me make a couple of points regarding the inspection report. The first is that this court has repeatedly said that where there's an home inspection, it creates an issue of fact as to whether reliance on a disclaimer on a representation is justifiable. This is a motion to dismiss, so any issue of fact has to be resolved in favor of plaintiff. Second, the issues that were identified in the home inspection report did not relate specifically to the issues giving rise to this lawsuit. There's no overlap between what the inspection found and what the claims are here. Because of that, and further on that point, the author of the inspection report, the home inspector himself, submitted sworn affidavits saying that the report that he authored based on the inspection he conducted would not put typical home buyers on notice of the defects that were actually found in this home. In fact, he said that what was found on his report compared to what was later found after the Youngs moved into the home was the greatest disconnect he'd ever seen in his years of experience. Given that the home inspection report did not put did not relate to the issues that were found.
Didn't it discover enough extensive water damage, both in and out, some in and outside the house, that would have given you cause to do something more, like maybe not buy the house or take more than $150,000 off of it, or get somebody else in to do a more extensive report? I mean, how can you claim that you could justifiably rely based upon once you got that report?
So I would point, Your Honor, to the TIAA Global case, to the Jablonski case, to the Richardson case. Each of these decisions say that where there's a home inspection report that points to issues, even that are potentially related to late facts that were later found, that might have given hints that further inspection might have been warranted, that's still a question of fact that can't be resolved in a motion to dismiss. And again, I want to emphasize the point here that unlike the cases that the defendants cite, the actual issues giving rise to this claim were not specifically uncovered in the home inspection report. There were classified by the inspector himself as relatively minor issues that had nothing to do with the extensive mold and water damage that was found on every floor of the home that required the Youngs to move out of this house after merely a month of living there. Those issues simply weren't turned up in the home inspection report. The Slauers.
Why is it that they weren't turned up in the home inspection report, but you're sure that the sellers knew about them? I'm having trouble with that what seems to me a serious contradiction.
Well, there's 2 points in that, Your Honor. The first is that we allege in the complaint that the reason it didn't turn up in the home inspection report is that the sellers took steps to actively hide those facts from the inspector, taking steps like painting over wet patches on the ceiling.
But isn't that the inspector's job to know that?
No, well, to give another example, wrapping pipes with electrical tape so that the leaking stops. That's
But wouldn't that be something, again, that the inspector would see?
No.
See a pipe, even I know if there isn't a pipe wrapped around with electrical tape, that doesn't seem right.
Agreed, Your Honor, but the pipe was behind a wall. And there's no expectation, there's no requirement as a matter of law that a home inspector rip open walls to determine whether every pipe is in its original condition, whether it's been wrapped in electrical tape or not. That's simply not a requirement that any court has ever found. In fact, courts have repeatedly found that in instances like that, where plaintiffs have, where sellers rather, have covered over cracks in foundations, where they've covered over wet wood with dry wood, that tricks the inspector, that creates an issue of fact that can't be resolved on a motion to dismiss, that has to be resolved by the fact finder.
Okay, let's hear from your adversary. You'll have a few minutes to respond. Thank you very much.
Good afternoon. May it please the court, I'm Alan Zuckerbrod for the respondents. Let's focus on the inspection report. That inspection report highlighted and identified about a dozen areas of water penetration. Essentially, the appellant's argument is, well, I didn't see item 13, 14, and 15. The inspector was very specific there. This wasn't an inspector that went in, didn't find some problems. He found the problem that they now use as the basis for their fraudulent inducement claim. There are a couple of very important items in the inspection report. At the beginning, he has a repair and replace designation, which he used for the water problems. And that's defined. It says the item, component, or unit is not functioning as intended or needs further inspection by a qualified contractor.
And in fact, wasn't there a reduction in the sales price?
Well, of
based
course,
on
and Justice Kaplan pointed that out. So big picture,
right?
they had
So it was
agreed
the
upon.
argument-
Wait.
So I think the plaintiff's argument is he saw it, but not as extensive as we later found out, right? So how do you deal with that?
Well,
You
number
point to
one, there are,
and I'm not relying on any of your representations about the property.
right, well, number one, they were clearly on notice. In fact, the inspector says, you should go look further.
Did the plaintiff ever do that?
No.
Did the plaintiff ever allege that the plaintiff tried but wasn't able to?
Absolutely not.
Did the plaintiff
The
say
purchasers had
anything
full
about that?
inspection, right? It was never alleged that they were thwarted in their ability to inspect further.
Did any of the representations survive the closing?
They did not, and that's why they cannot sue for breach of the representation. So they try to pigeonhole this into a fraudulent inducement. And I do want to point out, there were no issues of fact here. The court below, in its opinion, accepted the falsity of the representation, which was highly qualified to begin with. And it also stated that it was accepting for the purposes of the motion that it was used to induce the buyer to purchase the property. But the critical element here, Your Honors, is there could be no justifiable reliance as a matter of law. And the cases in this division and others are clear that that doesn't work. If there are no other questions, I'll rest on my brief.
Any more questions? Okay.
Thank you.
Let me correct the record on one point, which is what repair and replace means in the contract, in the home inspection report. It doesn't just say you have to go in and do further inspection. It also, one of the possibilities is also, or subsequent observation. That's on page 85 of the record. Subsequent observation doesn't put the homeowner on notice that he needs to go in and tear down walls and rip up floorboards. So that's not what
put you
repair and
on
replace.
notice that you should go in and do a further inspection?
It doesn't, Your Honor. In the TIAA Global case, I want to draw your attention to once again. In that case, it was a whole building, but the building inspector in that case found that there were air infiltration issues in the building. It was a large apartment building. That ended up being the issue that a later inspection following the purchase discovered was the problem. In fact, the building was basically hollow in that case. There was no insulation. The fact that the purchaser was aware in that case of an issue that was in some way related to the later discovered problems was insufficient to defeat the claim on a motion to dismiss. It created a question of fact on the question of reliance.
Specifically and directly excluded reliance. You said, I am not relying on anything that the plaintiff said or talked about or did, correct? I can read it to you. I have
Yes,
it
no, I
right
understand.
here.
I'm familiar with the
it's
provision.
straight up, I'm not relying on it. I disclaim, affirmatively disclaim reliance. So now you allege in your complaint, I relied.
On a provision of the same contract.
I mean,
There's
I
not
can
a-
give you 30 cases where we have upheld that.
No,
You
Your Honor,
cannot-
if I may, Your Honor.
How about the bedbug case, 8587 Pitt Street, where there was a express, I am accepting the property as is, and I am disclaiming any of reliance on anything the plaintiff says about me. We upheld that.
No, and Your Honor, in every one of those cases, the alleged reliance was on statements extraneous to the contract, usually oral statements. I'm not aware of any case, and I've read the 85 Pitt case. I'd encourage you to reread it. I'll reread it myself. Defendants have never cited any where a disclaimer provision has applied to contracts, to language within the same contract. The representations are always extraneous. If the disclaimer provision applied to representations within the same contract, that representation would be meaningless. A representation on which a party cannot rely is the same as no representation at all. And there's no explanation for what the representation would mean if it became null the moment that the contract was signed because of the disclaimer provision in the standard form portion of the contract.
Okay.
I appreciate it. Thank you very much.
Thank you both very much. We will take a look further. And last case for argument is Broom Lender versus Empire Broom. Good afternoon.
Good afternoon. May it please the court, Howard Kingsley, attorney for plaintiffs. This is a simple commercial mortgage foreclosure case. The Supreme Court below erred with respect to two primary issues. The first one was whether the lender established summary judgment as a matter of law, and the second one was whether the lender established standing as a matter of law. And based upon the record before your honors, we respectfully submit that there are absolutely no issues of fact, and that lender should have been entitled to summary judgment as a matter of law. Simply, there is no need for a trial here. With respect to the lender's prima facie case, the law is well settled. It's not disputed by respondents. You need to show a note and mortgage that's executed and binding, and those were both admitted in the answer. The only other element you need to show is that there's a default under the note. In Bank of America versus Brannon, Justice Gesmer had a dissent in that case, and I'm quoting, she said in that mortgage foreclosure case that where a foreclosure plaintiff was able to establish its prima facie case without reference to its own affidavit, summary judgment was warranted. And here, the borrower has not, although having many opportunities, denied any default. It's uncontroverted. They didn't deny the default when they opposed the motion to have a receiver appointed. They did not they did not argue that they did not default in opposition to summary judgment.
How do you justify the fact that you didn't actually attach the hardship application to your summary judgment motion papers?
It was annexed, Your Honor. It was
Not
annexed.
to the original motion papers?
Yes, it was. It
It
was.
was referred to, but I thought it wasn't annexed
No,
until
it
the
was specific.
supplemental.
It was specifically annexed, Your Honor. It's on page 327 of the record as Exhibit F to Mr. Bonneville's September 2nd, 2001 affirmation and support. It was specifically annexed. And in that hardship declaration, the borrower said, I can't pay the mortgage. Significantly, that statement was made after the loan undisputedly matured months prior to that time. So, notwithstanding the fact that it wasn't controverted on summary judgment or the cross motion that respondents made, or even on this appeal, they don't say, I paid. On the hardship declaration alone, we believe we proved our prima facie case, as well as their failure to contradict in any way, shape, or form. Now, they're saying that the hardship application is not an admission of liability. It's just an attestation of defendant's financial condition. Well, it's the same thing. They didn't pay a debt on time, and that was their problem. So, Supreme Court overlooked these undisputed facts and that there's absolutely no reason for a trial.
What about your standing, given the assignments that went on and who knew what and who could say in the affidavit, I was aware of this, I looked at these documents, because there were a few different assignments,
right,
which so often happens.
One of the things that Supreme Court also did not correctly do is analyze the elements of standing. There's not one way to have standing. There are various ways. And the courts throughout the state, the federal courts, the Second Circuit, are all in agreement. You can establish standing either by the assignment of a note or as a holder. And there are several ways you could show to be a holder that you're in physical possession. Here, the assignment of mortgage specifically assigned the note. It's clear as day. And Supreme Court ignored that and didn't look at it in terms of what was actually being assigned. Supreme Court, unfortunately for us, was too consumed with the affidavits and how they may not have been.
Yeah, but that's not really fair because you attach allonges that don't match up to the affidavit. So, like, own it.
Your Honor, I do, but the allonges are a separate
Right,
way
fair enough.
standing.
But you're
So that's what I'm saying. With respect to the assignment, I agree with you, okay? With respect to that. If we even go so forward as to the next way we established standing by annexing the note and mortgage to the complaint. The cases are clear. In fact, in Deutsche Bank,
Was there any dispute that the assignment was valid?
no. In fact, in
And
their
you attached
answer-
the assignment?
I'm sorry?
And you attached the assignment?
Yes.
And you had a statement of material facts that said that this was a valid assignment, correct?
Yes, it's
And
recorded.
was that disputed?
No.
Right.
It's recorded. In fact, they even mention it in their answer. In their defense for standing, their only claim of standing was that, oh, it might have been assigned, but it hasn't yet been recorded, so therefore the case isn't ripe and you can't go forward. And they specifically refer to the assignment. And just if I may, even though the red light is on, just to deal with the attachment issue, this court has stated, in fact, some of the justices on the panel have stated, that where there is an assignment and it shows what it is, how you got the paper is irrelevant, and respondents have agreed to that. So we've proven our prima facie case, and we think we've established standing in several ways, both as a matter of law.
Okay, let's hear from your adversary, and then you'll have a couple minutes to respond. Thank you.
Good afternoon, Your Honors. May it please the Court, David Salhenik on behalf of respondents. Let me first address the hardship declaration, which was a bit of a sticky issue. The plaintiff did put the hardship declaration in as part of their summary judgment motion, but they did it solely to argue to the court that the hardship declaration law no longer applied.
Once it's in there, we can rely on it, can't we? They don't have to say, if it establishes their prima facie case and they don't say that, but it does, then why can't we rely on that?
Well, the Supreme Court could only deal with the arguments that were before it. So there was a hardship declaration put in, but no argument was made to Supreme Court that this somehow proved that there was a default.
But the court can also, we can certainly look at what's in front of us, and if there's a document that put in on behalf of the owner saying, I'm in default, why can't we pay attention to that? We should ignore that?
Your Honor, you shouldn't ignore it, but that was not the basis of plaintiffs' alleged purported proof of default on their motion, and Supreme Court didn't consider it.
Did you in any other way oppose their claim that there was a default in your paying the mortgage? I think it became due in March of 2021, but I could be wrong. Did you ever state that? Did you ever?
Certainly we did, Your Honor. It's page 172 of the appendix. In our answer, a verified answer, we denied the substantive allegations about there being a default. So
Did you ever put in any evidence? I mean, this is a summary judgment motion, so you have to put in evidence, not just a claim in a complaint or an answer. So did you ever put in a claim, evidence that shows that you were not in default of this mortgage?
Your Honor, I think in the lower court, counsel took the position that correctly that it was plaintiff's burden and that plaintiff had not met its burden, and that was what Supreme Court found.
Once the hardship application was in, did you put in any documentation that said, oops, that was a mistake, it's all wrong?
Your Honor.
If not, why shouldn't we rely on it? Because it's a document submitted to a government agency
signed
in order for you to get your client to get a benefit. Why shouldn't we rely on that?
Your Honor, two things. First of all, our clients in opposition on the summary judgment motion never made the argument or addressed the hardship declaration because it was simply the only argument made by plaintiff to Supreme Court was the stay doesn't apply, not disproves liability. But we do address in our brief on appeal the fact that the hardship declaration plainly was intended simply as a borrower protection mechanism to get a stay during the
Therefore, it included a false statement about your being in default?
Well, our position is, Your Honor, if you look at the legislative intent of the act and the fact that the Act specifically provides that the hardship declaration cannot be modified by the borrower had a choice here, which was to put in the hardship declaration, which every single other borrower was doing.
Well, but one assumes that it only put in accurate and truthful hardship applications.
Well, Your Honor,
Shouldn't we assume that?
I don't think that can be assumed, Your Honor. Respectfully, I don't think that can be assumed. No, I can assume that they put it in with truthful intent, but we can't assume that hardship declaration was a statement that admitting liability. First of all, as we note in our brief, no court in New York has ever found that the hardship declaration can comprise.
But there are certainly many courts that have, many times our courts have held that you can't get out from under a statement made in a tax return. Why is this any different from that? In some ways, it's very comparable.
Your Honor, I would think this is different than a tax return because.
Why is it not an admission?
First of all, Your Honor, if there was an argument made in Supreme Court that it was an admission, certainly we would have responded. But again, the purpose of the hardship declaration is simply to say, in our view, assuming arguendo, there's a claim here, we should have a stay of the proceedings. It's not a factual statement.
It's a sworn document, isn't it?
It is a sworn document, Your Honor.
So we're supposed to think that you lied on that?
No, Your Honor, it's not a misstatement. It's just, it's not meant to address, the purpose of the hardship declaration is not meant to address whether or not the borrower is liable. It's simply to say, there is a claim against me by a mortgage holder and
I'm in default, and I'm telling you, I'm swearing that I'm in default. So you're in default there.
That's why
you're
you
in
need the
default here.
money. That's why you're in hardship. I mean, I don't understand how it can be true for this and not for that.
Your Honor, there's no factual record here as to what the borrower's intent was.
Well, I don't know. I don't see where the intent is there. When you put in a document such as a hardship application to a government agency and you swear the truth and you sign your name, you can't come back later and say, well, for that purpose, I meant it. But for this purpose, I didn't mean it.
Well, Your Honor, just to be clear, the hardship declaration does not say I'm in default. The only thing the hardship declaration
can't pay my
does say
mortgage.
is I'm unable to pay my mortgage, which is a statement of financial condition, not an admission as to the underlying claims in
So
the
wait,
act.
in opposition to the motion for summary judgment, did you argue that you weren't in default?
I don't believe that there's anything in the record to that effect.
So you didn't even argue that you weren't in default. You accepted that you were in default, correct?
We did not accept
You're
that, Your Honor.
saying that you didn't think they made out the prima facie statement, so you didn't bother dealing with it. Do you want to take 15 seconds to explain to us why you think there's an issue on standing?
Sure, Your Honor. With respect to the assignment, and I'll be quick here, with respect to the assignment document that was put in here was defective because it was missing the Schedule A, which was the legal description of the property. You'll notice, Your Honors will notice, the court didn't even consider the assignment because what it had in front of it was essentially half a document. We cite several cases in our brief to the effect that when you want to prove standing or when you want to demonstrate a document, you've got to put in the entire document. You can put in half a document, which is what happened here. So the court, without the legal description, could not know what property.
Doesn't it have a CFPBD number on it or whatever? I think
Something
it's
like
CF.
that. CF something.
Unique number.
Which refers to the its filing number and the.
Yeah, Justice Scarpullo, two things on that. First of all, we say in our brief, and we believe it's correct, that the Supreme Court was not obligated to do what we call detective work.
It's not really. I mean, it's there. You're saying that this one thing wasn't there, but the question is it that document and is it recorded? And those two, that number confirms that.
Well, there's no evidence from the face of the document that that number relates to this
Doesn't
property.
it match the property? Doesn't it match what's on the documents that are submitted? I think I looked and it did. Maybe.
It may, Your Honor, but what's important
I
for
think
the
it does, actually, right?
It may, I believe it does, Your Honor. Frankly, I haven't looked.
You didn't do the detective work.
What I would note is one thing that the Appellate Division, the Second Department, has held is that when there's a discrepancy between what's on the face of the document and the legal description controls. So that,
But there is no,
exactly, there is no legal description.
no, there's no discrepancy.
Well, it's impossible to know if there's a discrepancy because
From the CFN number or whatever.
no, there is a CFRN number, but it refers to a legal description, a meets and bounds description, and there is no meets and bounds description in the record before Supreme Court. So because that legal description, that meets and bounds, Schedule A controls, if there is any discrepancy, the court would just be speculating about what is in that Schedule A, and plaintiff failed in its burden to put in Schedule A because ultimately that Schedule A is what controls if there is a discrepancy.
Okay, I think we got it. You have a couple minutes if you want to address any of the issues your co-counsel.
Great, thank you. Just with respect to the default and the statement of respondent that it doesn't say that I was in default just as I was unable to pay.
Right.
It was post the maturity date, and the exact language is that the borrower is unable to pay the mortgage in full.
And what was the date of that hardship? Was that September
2nd, 2021.
And am I right that the mortgage came due about 6 months before that,
Correct.
in March?
Correct, Your Honor.
And would you address the issue that counsel raised about the absence of a description of the property?
Yes. In their reply papers, they just state that there's no way to ascertain from looking at the face of the assignment whether it relates to the subject property.
Right.
And we pointed out, in their opposition, and in our reply, we pointed out that you can because there's a block and lot number and it states the Manhattan. So that's the same block and lot that's in all the papers, meaning not only the allegations in the case, but also in those recorded documents. With respect to the legal description that's on ACRIS, and this court could take judicial notice as we stated in our brief, the legal description, and I looked at it myself on more than one occasion.
You did the detective work.
It's the same legal description on all the documents. The first mortgage, the consolidated mortgage, the allonges, it's the same legal description. So I don't think that argument has any merit whatsoever. Thank you for your time.
Thank you. Thank you both, counsel.
Thank you, you too.